And we are now on item number 11, which is the Executive Officer's Report. Jenny?
Okay. Good morning. It shows on. I'm not getting the sound that I normally do. But
We hear you.
no, pardon me. I am. Now
You're on.
I can
You're
hear.
on.
Okay. All right. Good morning. This morning's EO report's relatively short. I'm going to just provide an overview of a guidance document that the FDA recently released the end of June on a delay in the implementation of their track and trace component that is a serialized number that has to be added to products or homogeneous cases. They've postponed it 1 year from November 27th, 2017 to 2018. So when we were doing ePedigree in California, we had a series of opportunities to delay our ePedigree requirements. We are now at the federal level. They got an additional 5 years for compliance, and they're still not ready. So the FDA has pushed back the compliance date for manufacturers to have an identifier on the product that can track certain information, and the rest of the supply chain has the same dates as what was enacted in 2013 when we got preempted. So this is a guidance document. There's a copy of it in the board's packet. It's provided for information only. We'll do a quick update in the board's newsletter in the next issue. We have the opportunity to submit comments. I don't think that I would recommend to the board that there isn't much point in submitting comments on these. But that's pretty much, and I locked my computer, so I don't even have my notes in front of me, so I'm just ad-libbing here. So, any questions?
I just have one question. I'm sure we're disappointed, but, do we think, and this is maybe just a really random question you're not going to be able to answer, but I mean, because we're always worried about the consumers and bad stuff getting to the people in California. I mean, do you have heartburn because it's been delayed a year, or do you feel like there are checks and balances in place that have occurred over the last years as we kind of got to this point that maybe that it's going to be okay? And if that's not a fair question, then just say I can't answer it, Debbie.
Well,
go away.
we don't know what we don't know.
Yeah.
That when we're advised that we've got a compromised product, we're not talking recalls here, we're talking about
Yeah.
something that's been
Yeah.
re-entered. But we do know that continues to be rings set up where they buy drugs back from patients, they go out of state, they get repackaged into manufacturers' old containers, and then they get re-enter the supply chain. That's one way we get.
And we don't think,
medication.
and we haven't.
We can't detect that.
Okay.
We can't detect that. We would have been able to have serialization, which July 1, 2017, the full supply chain would have been fully serialized and implemented our tracking requirements had we not been preempted.
Yeah.
So we don't know what we don't know. We're not aware of thousands of people being injured by counterfeit medication. I don't think that there's a study out there to indicate that. It's just those of us that work in the area identify products that are found where they shouldn't be
Yeah,
found.
and it'd be kind of hard, I mean, sometimes you don't know that you're taking counterfeit. I mean, unless something really bad happens.
We generally think in the U.S. that we have a gold standard of product compared to the rest of the world, where 30 to 50% of the product you come across in some of these countries is counterfeit or somehow substandard. We don't risk, or we don't think and get fearful before we take medication in the U.S. that we could have a compromised product in front of us. So to the degree that we're not so concerned about our drug products that we have to track them serially as we would propose to protect ourselves, I think that's probably a good thing. But we don't know what we don't know.
And so I guess, I mean, I tend to agree with you that maybe we don't even make us send a letter or anything, but then the other part of me thinks maybe we should make a statement that we are disappointed and we think that this is a public safety situation, and we would like to, we would hope that this will be the last delay, that something to that effect. and I guess I'll even make a motion that the board does send a letter. And I know this is, like the Little Board of California going up against, the FDA, so kind of like, whatever. But, so I'm making the motion because I think it would be appropriate for us to make this statement.
It'd be my pleasure to second that motion. And we worked very, very hard on e-pedigree and for the protection of the patients of the state of California. And sad to say, first of all, we were successful. And then secondly, because of the federal regulations, and I don't mean this as a political statement for a particular politician, but ours got trumped. And and so anyway, so the state of California and the patients of California are where they are. With my sadness because of the inability of our e-pedigree, to become the standard for actually the country. And so I would underscore your motion absolutely.
And Stan, I appreciate that. And Jenny, I just look to you to tell us if this is a dumb idea that we're going up against the FDA and this would put us in, so if politically if it's not a good idea.
It wouldn't hurt us,
No.
Debbie. I mean, it
Okay,
would-
that's what I want to hear.
Yeah, I don't think it's gonna
But I
hurt
think
us.
then if it doesn't, then that's why I made the motion. So I think we need to at least make the statement.
We spent a lot of time, a lot of effort, and we had a number of companies that spent millions of dollars to get ready for e-pedigree, even though it was never fully implemented. We had a number of companies that spent more than $1 million to get ready for serialization. So there was a lot of work done by a lot of players when it was disbanded. So, yeah, we can go ahead and.
Do you want that memo to come from the board president?
Yeah, I think that would be
I think so.
appropriate.
Okay, great.
Would it be appropriate from both?
Yeah, we can do it from both. Perfect. Okay, so there's a motion and a second. Any public comment before we take vote? If not, all those in favor, raise your hand. Okay, unanimous. And I just wanted to set quorum. Yeah, I was actually, Cheryl just reminded me, if we could do a roll call and set quorum, especially since Debbie wasn't here yesterday. Debbie, you want to start out?
Sure. Debbie Veal, professional member.
I'm John Kahn, public member.
Stan Weiser, professional member.
Victor Law, professional member.
Amy Gutierrez, professional member.
Alan Chad, professional member.
Lavanza Butler, professional member.
Greg Lippy, public member.
Ricardo Sanchez, public member.
Albert Wong, professional member.
And I also wanted to congratulate Debbie Veal and Cheryl Butler for their reappointment to the Board of Pharmacy, another 4 years. So congratulations to both of you. I know we did Cheryl yesterday, but congratulations. Looking forward to continuing to work with both of you.
Love me or hate me, you got me 4 more years.
And me too.
Yeah.
Okay, the second part of the board's EO report is actually a report on cures, and today we have some colleagues from the California Department of Justice that work one way or the other. I know certainly one of them works intricately with the Cures program. I'm not so sure about you, but I know you're somehow involved. I just don't know roles yet. We just have some new players. So what we've asked for is a report on the status update of our prescription drug monitoring program for controlled drugs in California, which is Cures. Our pharmacists and pharmacies help pay for it, but it's administered through the Department of Justice. And so Tina Ferralis, I know, is going to provide some of the information, so.
Okay, thank you, Jenny.
Would it be helpful for us to do introductions?
Yeah, and a little bit what you do, so if nothing else, I at least know next time how to better introduce you.
Okay, my name is Tina Ferralis, and I'm one of the managers within the Cures program.
Hi, I'm Melanie Fontes Reiner. I'm the Attorney General's special assistant that handles all healthcare issues. So it's a priority for the Attorney
thank
General,
you.
and so we're excited to be here, and thank you. And then my colleague, Renica George.
Hi, I'm Renica George. I'm part of the Office of Legislative Affairs at the Attorney General's office, also handling healthcare issues.
Would you like to sit at the table, too? We can add a chair.
Do
Sure,
that.
I can just pull a chair out.
So do you guys work for Mike Small or with Mike Small, or how does?
We work with Mike Small, but we report directly to the Attorney General.
Okay.
I sent it to her.
Thank you.
Your colleagues of his. Okay.
And I'm sorry, is Mike Small still around?
Yes, and actually in the room is
There
Mike
he is.
Small, and also
I'm like,
sitting,
we're used to seeing him.
Yeah.
Oh, sorry, Mike.
You're gonna have
He's
to get your
here.
TV tray, Mike.
and with Mike Small is Audra Opdyke, our Assistant Bureau Director over the CARES program. Okay, so I'm going to, for you today, give you a brief overview of the CARES program, a little bit of the history, and provide you some updates on what's going on with CARES 2.0. And I do have a PowerPoint presentation here that I will be referring to. Once upon a time in 1939, I'm just kidding. Actually, the earliest form of the program started back in 1939, and initially it was the California Triplicate Prescription Program. It was within the Department of Justice, and at that point in time, the only types of controlled substance dispensed prescriptions that were reported to DOJ were certain Schedule II controlled substances. 1939 was quite a while ago. You know, the wheel was invented since then, the light bulb and everything like that. Computers eventually came around. So I would say it was probably a few decades when all of the prescription information was in paper format, and we kept it in probably files or boxes or whatnot. And eventually we did develop a automated triplicate prescription system where we entered the prescription information into that system. It wasn't until 1997 that the CARES system was initiated, and initially it operated in parallel with the triplicate prescription system, and spent a couple of years evaluating the efficiencies and doing comparisons against both systems to see which would work better. By 1999, CARES replaced the automated triplicate prescription system, and over the course of a few years since 1989, we started collecting not only Schedule II controlled substance prescription dispenses, but we also collected Schedule III and Schedule IV dispensation data for California. As you all know, the CARES database is a repository for the reported dispensations of those controlled substance prescriptions. So in 1999, CARES replaced the automated triplicate prescription system. By 2005, the automated triplicate prescription system and the triplicate program was decommissioned. Triplicate prescriptions were eliminated by way of Senate Bill 151, and CARES became permanent. In 2009, the department developed a PDMP mechanism or tool where people could actually query the system. So it wasn't until 2009 that we made applications available to pharmacists and prescribers to have a CARES account and actually, once approved for an account, query the CARES database directly. So that wasn't until 2009. And in 2016, we launched the CARES 2.0 system. I do want to mention a little bit of, a few events that happened actually between 2009 and 2016 for the Department of Justice. We experienced in 2011 some severe budget cuts, and at that point in time, we lost within the Division of Law Enforcement a couple of important bureaus in the department. We lost the Bureau of Investigation and Intelligence, as well as the Bureau of Narcotic Enforcement. The CARES program used to be in the Bureau of Narcotic Enforcement, and when that completely dissolved in 2011, they placed the CARES program away from Division of Law Enforcement and put it into the Division of Criminal Justice Information Services. So that was by the end of 2011, after the fallout with all the budget cuts. So the timing of everything and all of this greater attention on the opioid epidemic and the greater acknowledgement of the importance of PDMP systems in addressing that epidemic became more apparent shortly after they got rid of everything. But anyway, since then, we were able to do the CARES 2.0 launch, which we managed to do in 2016. Okay, so that's the history in a nutshell. The statute governing the CARES program is found in California Health and Safety Code Section 11165. What I have here is 11165A, which defines who can have access and for what purpose. And it is meant to assist healthcare practitioners in their efforts to ensure appropriate prescribing, ordering, administering, furnishing, and dispensing of controlled substances. It's also allowed for law enforcement and regulatory boards in their efforts to control the diversion and resultant abuse of Schedule 2, 3, and 4 controlled substances, and also it's made available for statistical analysis, education, and research. So here is a table of stats. I'm not sure if you're able to read that, but this is a reflection of the number of registered users we have in the system. This shows the monthly totals, and if you can see, hopefully, I actually can't see it myself from here, but anyway, you can see we have a grand total between the prescribers and dispensers. We have a grand total of nearly 170,000 registered users in the system, and this is as of the end of June 30, 2017. As far as a breakdown, you can see here that we have 129,000 or so prescribers enrolled in Cures and 40,000 pharmacists enrolled in Cures.
So in your chart there, dispensers are pharmacists?
Yes, yes.
Can you do me a favor if somebody asks a question without the microphone? Can you repeat it, please?
You want me to go back
Tina,
there?
when you
right.
provide a, thank you.
Yes, the question
Thank you.
was
Getting put
if...
to work here.
Oh, now I have to do that too. Anyway, the question was if dispensers represented pharmacists, and the answer is yes, that represents pharmacists. Okay. Okay, this next slide, this represents the numbers of patient activity reports, or PARs, that were ran each month in 2017, and I'll just jump over to, I'll review May and June of 2017. As far as prescribers go, in May of 2017, the prescribers ran 373,000 patient activity reports, while the dispensers ran 571,000 patient activity reports. Collectively, between the two roles being prescribers and dispensers, they ran 944,000 patient activity reports in May. And in June, the numbers increased. Prescribers ran 432,000 patient activity reports. Dispensers ran 636,000 reports, and collectively, over 1 million patient activity reports were ran in the Cures system in June of 2017. This slide, similar numbers, but this shows system access. Again, the numbers are rather similar. Prescribers ran over 200, or actually accessed the system over 200,000 times in June of 2017. Dispensers accessed the system nearly 300,000 times in June of 2017, and collectively nearly 500,000 times the system was accessed by those roles. If you're noticing the trend, you can see that the pharmacists are quite the heavy users, and that's quite impressive when you consider the fact that there were about 130,000 prescribers enrolled and 40,000 dispensers enrolled, but the heavy-duty users of the system actually are the dispensers. This is a visual representation of the stats that I just went through. You can see here, this is registrations again, and these are registrations for each yearly period. So you can see for each yearly period, there was an increase each year for prescriber and dispenser registrations. On this chart, the dispensers are the red line and the prescribers are the yellow line. And clearly you can see the big spike in 2016. We had the most registrations that year, and that was mainly driven by the requirement to register by June 30, 2016. So that was our big year for registrations. 2017, not too many registrations so far, and remember this represents half a year of 2017, and also we've got the majority of the licensees registered, so we're just waiting for either the stragglers or the new licensees to onboard onto the system. This is another graph representing representing PAR generation. Again, the prescribers are the yellow line, dispensers are the red line, and you can see the utilization for the dispensers nearly double the amount of access in PAR generation compared to the prescribers. 2017, like I mentioned, we're only halfway through the year, although I expect that to equal or surpass the utilization levels than what we had last year. Okay, more stats. This actually, in this slide, we're looking at a different period. We're looking at an 18-month period. We're showing here the utilization for prescribers, dispensers, and also law enforcement users. So that's the third column on this chart. Here you can see in this 18-month period that prescribers ran, let's see my point, ran almost 5.8 million patient reports in this 18-month period, and dispensers ran 9.5 million reports in the same period. Law enforcement users ran a little over 2,000 reports in this 18-month period. As far as number of law enforcement users, we have about 1,300 enrolled in the Cures system. More graphs. This is a visual of some of the stats that I just summarized. Here, the dispensers again are the red line. This time, the white line is prescribers, and if you can see, there actually is a green line at the bottom that represents law enforcement usage. But here you can basically see visually just how much the dispensers and prescribers and law enforcement users are utilizing the system. Okay, Cures 2.0 application updates. As I mentioned, we launched the Cures 2.0 in June of 2016. That was a broad release of the system. In March of 2017, we decommissioned the Cures 1.0 system. So there was a period of time where we actually made available Cures 1.0 and 2.0 available together at the same time. And we did that primarily to help accommodate those facilities who did not have the most current secure internet web browsers to access Cures 2.0. So we allowed plenty of time for those folks to get up to speed. And now that we've decommissioned Cures 1.0, Cures 2.0 is the only system, it's what's available to everyone, and that, again, requires the most current internet web browsers like Internet Explorer 11 or higher version of that, current versions of Mozilla Firefox, Google Chrome, or Apple Safari. One of the projects that we're working on presently, right now, we're actually embarking on a interoperation pilot. It's between Cures and UC San Diego, and we are now starting to partner with a company called Hydrant IDX, who is a National Institute of Standards and Technology sponsored program. You know, they're a sponsored vendor. They're receiving funding through NIST, and they are going to work with Cures and UC San Diego on an interoperation pilot. And in a nutshell, what this pilot would do, if successful, is it would allow prescribers and pharmacists to sign on to their native system, and in this case, our pilot is with UC San Diego. Sign on to UC San Diego system is the same as a sign on to Cures. So what that is sparing the Cures user is the need to have to remember another user ID and password. So once I log into my UC San Diego medical system, I'm actually already automatically signed into Cures. So this interoperation would help achieve that. Yes?
Is that only for UC San Diego affiliated folks? If I were
the
in
pilot.
Merced and, okay, so it's a pilot. Got
For
it.
the pilot,
Okay,
yeah.
You did say that. Okay.
Yes. Okay. Okay, and a couple of cases that are recent and noteworthy is Lewis versus the Medical Board of California. I don't know how many people here are familiar with that case, but in a nutshell, that had to do with, the scenario was the medical board was investigating a prescriber for issues unrelated to prescribing. And as part of the investigation, the board ran the prescriber's prescribing history in Cures, and the doctor complained that that was violative of his patient's privacy. So that's the summary of the case. On July 17th, the California Supreme Court affirmed the Court of Appeals decision that the medical board's accessing of Cures did not violate patient privacy. And the court says that board action was justified by countervailing interests, and that the balance tips in favor of the board's interest in protecting the public from unlawful use and diversion of prescription drugs and protecting patients from negligent or incompetent physicians. So that was July 17th. The other notable case that I wanted to bring up here is the Oregon Prescription Drug Monitoring Program in ACLU versus the DEA. In this case, the Oregon District Court ordered that DEA administrative subpoenas for PDMP data, and we're talking about Oregon, violated privacy interests. So the Oregon PDMP did not honor those subpoenas that came from the DEA, the administrative subpoenas. And on June 26th, the U.S. Court of Appeals for the Ninth Circuit reversed the Oregon District Court's order. And they stated that they also held, they held that the federal subpoena statute preempts the Oregon statutory court order requirement. So these two cases are noteworthy in that they reinforce or support the appropriateness for licensing boards and law enforcement to access prescription drug monitoring program data, which is why we wanted to mention that here today. Okay. Here's our contact information. That is pretty much everything that we had planned for updating you on today, unless there are any questions.
I've got a question.
Go ahead, Stan.
Mike, when you were here last, we talked about the possibility or the curiosity about Schedule 5 drugs, given their abuse and the diversion, and whether or not that was going to be something that Cures was going to be tracking in the near future.
Yeah, I already entered.
It's getting crowded up there.
I already introduced Executive Officer Harold with our Special Assistant to the Attorney General and our Deputy Attorney General for Legislative Affairs, and they're going to continue on those kinds of conversations.
In answer to your question, statutory changes would be needed to do it. And Amy and I met with DOJ to see where they were. We're just at the front end. The goal would be is to have either, it'd be a little unusual, I think, for a constitutionally headed agency in the governor's office, agency, the executive branch, to spearhead this, but we're both interested, and I know the medical board's also interested in some of these components, and so we would like to do a modification to the Cures program that will allow the ProMeth with codeine specifically, or Schedule 5 altogether. And a few other changes, a shorter time period within which pharmacies would have to report. There was a component for...
Yeah, and I guess that was my question, because I don't know why this would require a statutory change, but one of the things I think the medical board has proposed, and I really think this would be a great idea to protect pharmacies on diversion, is for physicians to be able to print their own reports. So if I'm a physician and I want to see what C2s or controlled substances I've prescribed, I could run a report and then I can adjudicate it against my scripts to make sure that those are really my patients. And that way we at least alert sooner that there could be a diversion problem. So I've been told that there's some kind of confidentiality. I don't quite understand that because I know other states are doing that. So are we anywhere close to allowing a prescriber to run their own reports?
For all their patients.
For their patients. So if I want to look at all my scripts and that I prescribed under my provider DEA number, why can't I run that report?
Yeah, the statute is very specific in terms of what authorized users can, who can have access and what they can do with the report, with their access, and it's very specific and narrow in that it's for patient care purposes, which is why the system is engineered and designed so that really all a prescriber and dispenser can retrieve is a patient report and not a prescriber or pharmacy report. So for that reason, because it is very specific, the statute would have to be relaxed in a way such that it would allow the department to make that feature available to the prescribers and the dispensers.
To allow to run their own report.
Mm-hmm.
Can I just pursue 5s again for a moment?
Can we just finish this one just to make sure, and then we can go to 5s? Any other
So,
comments?
yeah, I mean, obviously the Attorney General he was appointed in January, right? So we sort of are, I think the reference we've used is parachuting into the legislative session, right? We didn't really have an agenda going in. We're sort of, it's, you know, we are reacting to things and trying to be helpful where we can in a not fast enough way, because we're sort of learning as we go. There are a number of things, like my colleague just mentioned, Ginny had flagged that, you know, that we have been talking with Mike, that I think going into next year and the following year, you know, we are looking forward to working with you all and sort of thinking through how do we make the system better and how do we make it more usable and all of those things, right? And so I think we're certainly open to having those dialogues and looking to, you know, have a more robust agenda in the future. I think we are also trying to be helpful with the current bills that exist, right? Like AB 40, for example, and trying to provide technical assistance to the authors so that the bill functions as is and it fits within the CURE system in a way that, you know, is helpful.
Okay, so let's go back to.
Back to
Stan.
5?
Yeah.
So, is this something that the board should pursue with regards to statutory issues, including 5s or minimally Phenergan with codeine or promethazine with codeine? But I mean, is there any reason why we shouldn't pursue it?
Wasn't there a drug that they didn't want to be included for some reason? I recall that we had discussed this.
Well, there was one manufacturer that didn't want its drug that's currently a Schedule 5 drug to be included, but I've lately seen ads for that particular drug, and they start talking about if you have a narcotic problem, maybe you shouldn't be using this drug. But that's one for another day. I believe the board already directed us, which in that vein, Amy and I went ahead and started having some meetings. It just was not feasible this year to move ahead with the legislation, but we intend to go ahead next year, if nothing else, to find an author, and we would really like to collaborate with you, because we also want cross-state sharing of data, which was one of the other directives the board.
That was my next question. Yeah, cross-state, where, I mean, so here we are, you know, so close to our borders, and it would be so advantageous, many say, for the sharing of information cross borders, and so many other states do it. Is that being considered as an opportunity for California, and what would be a timeline on that if it is?
That's something that requires us to, again, that's not under the current CURE statute, we are not able to do that. And so it is something, as I spoke before, as we build a bigger agenda or a long-term pathway, the things that we are considering, you know, when we talk to Mike and Audra and the CURES team, that is, you know, on their list, and I know that it's on a number of other states are doing it. And so, you know, we agree that it is helpful as sort of combating the, you know, prescription drug abuse epidemic, but also, you know, it's something that we, I think we want to be thinking about in the future.
So, not to circumvent
Sure.
you folks, but even in a collaborative way, is that something that would be an opportunity for the pharmacy board and you folks, or for the pharmacy board to pursue from a statutory point of view?
We are happy to engage with you all. We are happy to talk with you. I can't commit to. I don't. You know, I've been 4 months in this job, sir. Unlike yourself, you seem quite prominent up there in that dais. So I'm not trying to get fired, but you know, I can commit that we are willing to talk with you about it and work on it and think about it.
Thank you.
Thank you. I have one quick question. Have you identified yet when you're likely to certify CURES 2.2 so that it would start the 6-month clock for the legislation that requires prescribers to check before they write a prescription? Or are we still working on some of the components?
We're still working on the prerequisite to the prerequisite.
The
prerequisite
further up.
Well, in order to file our certification, the department has to, you know, be able to certify the system is ready, which, you know, we're able to do that. But we're also additionally we need to ensure that we have adequate staffing in the program, which is what we're working fast and furiously at the moment. If some of you are aware of state hiring protocols, it's very tedious and time-consuming, and we're trying to onboard several. So that is part of the hold up in us being able to file. So the certification date has not been determined yet, but if we were basing it on our hiring practices and what we need to have done, my crystal ball makes, I'm reading maybe in the fall we'll be able to file the certification, which, as you know, once we are certified, then mandatory use goes into effect 6 months after. I'm not sure if anybody else's crystal ball reads a little bit differently, but that's my guess.
Thank you.
I have a question. The pilot that you're doing with UCSD, I don't remember, when did you say did that start, and when's the end point for that?
Well, we're just embarking on that right now. I believe once we get everything off the ground, and maybe Mike can correct me if I'm wrong, I believe we're intending on running that pilot period for about 6 months. 12 months. So, hopefully that'll be a quick 12 months and we'll be able to, have that proof of concept developed.
And the end goal would be that anybody with any pharmacy, whether it be a hospital system or maybe even a retail pharmacy, then would be able to kind of ping in and out of Cures easier.
Yes, it would simplify it quite a bit and help ease the workflow. So if they're interoperating with us, their sign-on into their system would be a sign-on into Cures.
Because actually, that's kind of almost a step in the right direction, Stan, to me, even going across state lines. And I know that's something that this board has said is one of our goals.
Right.
Thank you very much. Are there any public comments, questions? You want to come up to the microphone and?
Again, it's a little crowded up
Yes.
there, but.
So I understand this Cures program is one of the ways we're attempting to combat the opioid epidemic by tracking some statistics. So my thought is, would the Cures program in any way be able to alert the DOJ to doctors that are overprescribing? Because when we listen to drug addicts and people who come into the emergency rooms, they say they all started their addiction almost invariably with a prescription for a narcotic. So is Cures or the DOJ looking at least following the prescriber's use and prescription frequency?
One of the authorized users for the Cure system are the regulatory boards. And so the regulatory boards have not only the basic access to Cures, but they also have ad hoc access to the Cures data. So there is definitely a lot of ability and flexibility within the system to be able to do that type of monitoring.
And the recent Supreme Court decision has helped, or will help dramatically.
So does the medical board currently really reviewing is part of your record periodically? That you know of?
Yes, we do have some active medical board, regulatory board users in the system.
Okay.
And to add to that, what I believe part of your question was, we have a section, health quality enforcement, whose entire, or at least a good part of their purpose is to work with the medical board and the Department of Consumer Affairs and to, prosecute this kind of behavior. So we can, so we can increase enforcement and help get this under control.
Any other questions, board members? Thank you very much. Oh, one more.
I did see the updates that you have for the, was it Cure 2.2 or 2.0, with different web browsers, but is there any plan to perhaps have an app on the phone? When I work in the pharmacy, the computer system, switching from the computer system to the internet environment in some stores is not as user-friendly. And I can see also with physicians when I call them, they're in between rooms and they're constantly going and coming. So if there is any way, because it's really hard to get on the phone, on the internet, and be able to and get the password correct, and then it locks your account, which is exactly what's happening to me right now. So I've been with Cures for about 30 days, going back and forth trying to unlock my account. It's still locked. So, but they've been great. I mean, they are trying to help. But as a pharmacist who, is in the pharmacy in the community at least once, twice a week and per diem, it's just a little tough. So it'd be great if we can maybe do something like that. I'm not sure if we're limited in terms of technology.
No, you make good points. I actually have the same problem, so
Yeah.
I
don't recommend.
You're not the only one.
I don't recommend entering your password on your phone because it's very difficult to try to type it onto a small screen. But yeah, I'll definitely bring that feedback back to our folks. The IT people tell me anything's possible, but there's usually dollar signs next to things. So that actually is something that we have heard, and so as best we can, I know that that's a need. We'll bring it back and see how best we can try to accommodate. But I'm not the IT person, but nor do I have the funding for the IT to do all the different things. But that's noted. I'll definitely bring that back.
I think we have one more public comment.
Robert Stein, KGI School of Pharmacy and informaticist. I do want to compliment Cures and the DOJ for moving forward with integrating into EMRs, into pharmacy systems, Cures. That is going to dramatically improve compliance and workflows for clinicians. Second question, though, is related to one of the questions from the board members, which is being able to run a report, let's say if you're a prescriber, on your own activity. An analogous question is the consumer having access to what the Cures report says, because it's just like a credit history report. Sometimes wrong information can get on there, and a person is unknown. I mean, they don't know that they're actually being tagged. So I know that there were some statutes that were proposed, or bills that were proposed, to allow patients to receive a copy. Is that still on the table?
Yes, in fact, that actually is occurring now. There is the Information Practices Act, which allows a patient to make a request to the Department of Justice for a copy of their patient activity report. So that process does exist, and it is available to patients.
It's available now?
Yeah.
Yes.
The trick is getting on.
Well, the patient doesn't get on, but for the pharmacist or the doc, yeah.
Thank you very much for all
Very
you're doing.
informative.
Very
Thank you.
informative.
You're welcome.
Okay, we're going to move on a little out of order. We're going to move on to item, where is that on here?
Halfway through.
Okay, under the Org Development Committee, under the discussion, item E, discussion and possible action to increase the exempt salary category level for the position of executive officer. We're fortunate here to have Nicole here from the Department of Consumer Affairs, who is going to walk us through this. And this is, I understand, in order for us to entertain a salary increase for our executive officer, we need to do this in public session. So Nicole's going to walk us through that process. Thank you. Good morning.
Good morning. Thank you for having me here today. Thank you for having me today. And again, my name is Nicole Lay. I am the Assistant Personnel Officer for the Office of Human Resources, Department of Consumer Affairs. I am here to provide you with the process for the exempt salary level increase. And I believe you have been provided with a flow chart for the exempt level increase process. For this process,
It's attachment 5 of the board packet under the Org Development Committee.
Thank you.
And if you're electronic, it's page 19.
Thanks, Debbie.
In this meeting, the board may vote to increase the current exempt salary level after a discussion to evaluate the current exempt level against mitigating factors, and those such as licensee population increase, staffing level change, any new regulations that have significant impact to the board's operation, and the board's influence and impact at the state and federal levels. Those are examples of mitigating factors. The board will then identify the salary level that the board consider it is appropriate and is a direct reflection of the changes that the board has encountered since the last salary level increase in September of 2015. The board will then submit a written request to the Office of Human Resources, and we will prepare all necessary documents in addition to the board's justification. This package will be submitted to the Business, Consumer Services, and Housing Agency, Office of the Governor, and the California Department of Human Resources for consideration. I do want to bring a very important note to this, is that the Office of Human Resources, Department of Consumer Affairs role in this process is your facilitator. We are not part of the decision-making authority. All decisions regarding the exam level increase are reviewed and either approved or denied by the administration. So at this time, that's an overview of the process. Do you have any questions for me?
Well, I've got some information that I'd like to provide you as well as the board members in terms of looking at the background on this issue. There is currently a salary disparity between the staff that the executive officer oversees and the executive officer salary. So currently, the inspectors that work for the board make a little over $700 per month more than the executive officer. The supervising inspectors make $15, $18 more than the executive officer. So she's at a lower level than people that she oversees. And during this year, the board's assistant executive officer was in a position to be compensated at a level above the executive officer, but that had to be stopped because the assistant executive officer salary was then adjusted to $1 less than the EO's. So it's actually impacted both of their positions as well. Given that California is the largest board of pharmacy in the nation, we have over 140,000 licensees spread out over 25 categories of licensure. And in a salary survey that was just conducted by NABP this year in 2017, it was identified that the California executive officer salary is less than 42% of the nation of other executive officers. So we can share, I guess it's a confidential survey, but we can share that with you. The board regulates, very heavily regulated in a number of areas, not only the licensees, we're doing sterile compounding, also working with other state and federal agencies such as CDPH, DHCS, DEA, FDA, particularly in the area of complex investigation. And there's just a lot of complexity with the pharmacy board in terms of the oversight. And the board's licensing enforcement committees functions are a lot more complex than other programs in the department, as is demonstrated by the failure of the board to be able to use the Breeze computer system because of all the functionality differences between the Board of Pharmacy and the other boards. And just as reviewing some of the other board salary structures, there's others such as the Bureau of the New Marijuana Board. The bureau chief is at a higher level than the executive officer. So because of all these facts, and we really request that the department, and I don't know, do we need a motion, Laura, to do this?
You will, yes, but I want to offer just one piece of clarification here. We're talking about changing the salary level or range of the
Yes.
executive officer. We're not
Yes.
talking about setting the particular executive officer's salary. So the way a state system works in all state positions, there's ranges
Right.
that are available to each position. And so what we're speaking about right now is the range of your executive officer's salary. And for that to occur, the board can determine what it would like that range to be. And then obviously, as Ms. Lay has explained, it has to be approved by the appropriate control agency.
So we could vote to have that range be at a level that is above the individuals that she oversees, their ranges.
Yes, you can. So you're seeking to modify the range of the executive officer position for this board, and that would apply to whoever is sitting in that seat. So you're not speaking of your current executive officer's salary. You're talking about this is the range that is appropriate for the person who's for performing the functions of executive officer for this
Got
board.
it. Okay.
Is this
Amy, do we
impacted?
know what the range numbers are? Because, it kind of depends on the organization, but, is it, so do we know what, because obviously we need to provide Ms. Slay with, we recommend that the executive officer of the Board of Pharmacy be in salary category, and so what, is that a number, is it a letter?
The ranges are in letters, and
Okay.
it'll associate with certain salary ranges that attach to the letters. So I can
So
give
right
you-
now, I think she's at G.
Yes.
Or
right-
our executive officer at a level G.
And based on the information you got from, I'm sorry, was it NABP? What letter would be appropriate for the executive officer of the California Board of Pharmacy?
I can give you the ranges, the letters, and the salary that goes with the ranges. The board will have to make that decision and vote on that decisions. So currently, the executive officer for pharmacy board, the salary level is G, and the ranges is approximately $10,054 to $11,200. These are monthly salary. The next level after G would be F, and approximately the salary will be $10,320 to $11,498. The next level after F would be E. It started with $10,545 and up to $11,746. After E is D, start out at $10,925 and it topped out at $12,168. The C level is a dual level for...
Is a what level?
It's a dual level. They
Dual.
got two separate types of salary ranges that go along. The lower one is $11,071 to $12,335, and the higher level would be $11,425 up to $12,726. Above the C will be a B level. B level typically reserved for department director. And this one start out at $11,952 and is top out at $13,316.
In case if we apply for a upper level, if they deny that, would they recommend a different level for us, or we have to resubmit the whole process and ask for it?
I believe back in 2015, the board requested for the exam level to be assigned with the F range. However, the administration only approved level G. At that time, the exam level was J, and the board asked for F, but it was only approved at G.
That's
So
correct.
So for the board members, the inspector salary is $10,727, and the supervising inspector is $11,530. So if we're going to go at a level above that, we would
That'd be
have
D.
to at least go to E. Well, E, the top step is, and
D.
does that start out at, and Nicole, the question, since it's a range, does that automatically start at the middle or the bottom, or how does that work? Because there's a range.
When a person get appointed to a position, typically, if they are state employees, the recommendation that the administration would normally go with is they start out, typically provide a 5% increase from the current state employee salary. So it could fall anywhere at the beginning or at the middle of the salary range. It just cannot exceed
So it
the
depends
maximum.
on the current salary level, plus
typically.
5%, and then it goes up to the maximum of that range.
That is correct.
And could we make a recommendation that, like, let's say we feel like the executive officer of the California Board of Pharmacy needs to start someplace different, or maybe it is for the individual, can we make a recommendation for it to be more than 5%?
We're talking about, today we're talking about the salary level of the position. We're not-
category.
The
yeah,
range.
Yeah,
So
the
you're
range.
saying that whoever's in that position, this is what we believe as a board that our executive officer salary level range should be?
Correct.
Yes.
And and so the next step, which is how much should any given individual earn, is a question that you may address in closed session.
Okay.
Okay.
Nicole, we're a self-funded board, so the salaries are not going to be coming out of the general fund. Does that have any impact on the salary level that we can choose?
I don't know if that's something the administration take into consideration when they review these requests. Again, we're not part of that decision-making authority, so
Okay.
we only communicate whether or not it was approved, denied, or even modified, like they did back in 2015.
So if we stated that in our application or report, at least it would be considered.
Could you please repeat that?
If we stated that in whatever communication we're going to give, stated that we're self-funded and therefore we feel that should have an impact, they would consider that.
Possibly. They do review the memo that you will be provided if the board vote to increase the exempt level.
So just to go over these levels, if we're looking at the supervising inspector at 11,530, we have the option of level E, which is between 10,545 and 11,746. And then we have D, which is 10,925 to 12,168.
It seems to me D would be the appropriate.
Yeah.
I would agree.
Because as soon as the supervising inspectors got a raise,
We would be
we'd
back
now
in this
be back
deal.
in the
Yeah, right,
situation.
Yeah.
Why wouldn't you consider a C? Because that would be a minimum of at least 1145 to start out with. Then you don't have a long time to catch up with while the other people got a raise again. Then you're back to square one again next year.
Well, we may have to be realistic about this also.
Yeah, I think Stan's
Well,
right.
because your supervising inspector is making like 11,700. So which is
Was C the dual category?
the dual one, yeah, the dual one,
and
the dual one
just
start with
realistic-
11,710. I mean, that's the minimum of the supervising inspector.
Just realistically, in looking at the other boards that, because Nicole did give us a listing of all of the boards, it doesn't appear that there's anyone currently at a board that's lower than an F, is that right?
You
On
are
these?
correct, yes.
By lower than an F, you mean D or C or?
Yes.
Okay.
So
So
we're
the-
already, I mean, even asking for D would probably place her, except for this medical cannabis, the Bureau of Medical Cannabis Regulation, which has its own range.
And again.
That seems appropriate.
It's a newly established bureau. So it's a newly established bureau. We were not part of how that salary comes about. We got the salary based on the governor website upon the announcing of the appointment.
But like
Nicole,
Greg
you-
said, we are a self-funding board. We don't have to look for other boards for references. Plus, the other boards, are they the one with a bigger budget than what we have?
So I guess it's a question for Nicole. On the Bureau of Registered Nursing, it doesn't have a range. It just says not applicable license requirement, and that is higher. What is the difference there?
I do believe that the Board of Registered Nursing, the executive officer required to hold their professional license in
As a
order for
nurse?
them to be appointed.
Got it, okay.
Amy, could I make a motion that our board adopts or moves forward with recommending the salary category of D for the executive officer of the California Board of Pharmacy?
Second?
Second.
I would make a recommendation to move to C, because then you won't have a
Victor, we
problem
have
to
a
start out
motion
with.
and we have a second on the floor. If that turned out, then we can go to.
Okay.
And Victor, the only reason I went with D is because I think that C.
It's achievable.
Yeah, I think D is achievable, and then maybe next year we can try.
Remember what she said? If you ask for a high one, they could give you a lower one. So if I have a C, if they don't like it, they give me a D. So if you ask for a D, you got stuck with a D, you don't get anything better. So always ask for a higher one instead of for less. That's a strategy.
Nicole, is that an appropriate strategy in your experience?
In my experience, I think the board will have to make that decisions.
Yeah, you're very political.
I guess what I'm asking, let me ask it a different way. Have you seen that there's negotiation afterwards? So is there value to going a little higher so that we can get where we want? Or is it better to ask what we really want it to be right up front?
I don't know. I'm not aware of there has any negotiation going on after the board submit a request. I'm not aware of there has been any type of negotiation. But I do believe that the board, when you submit the justification and speak about the changes that the board has encountered, other mitigating factors as described earlier, the board can then determine that if the D is an appropriate level or C, you vote on that level and we'll help you put the package together and submit to the administration.
By asking for
Is
D.
cannabis a C level or what?
Medical cannabis has a different, it's 12,333 to 13,730.
That's a B. That's a B.
That'd be an A.
Amy? Yeah, I would like to make, I would, before the vote, I would suggest that, like Victor said, we should ask for a C because it's not right for the, supervising inspector make more money than our chief executive director.
I
Well-
withdraw my.
Well, let's be really
Thank you.
clear, just to go over the numbers, at D, the supervising inspector would be making less because the ceiling on that is 12,168. So I
But
just
the-
want to be really clear.
How does
The main
one-
thing, we have to justify, we have to show why we have to request that level, we have to justify it.
I'm sorry, Greg,
Exactly.
What was your?
How does one get to the ceiling level?
Nicole,
How
how,
does one get to the ceiling? Is it a number of years that they're in their spot, or is it based on performance and a number of years? Or what's the criteria to get from the lower or middle part of the range to the upper part?
The document that I have from the California Department of Human Resources, and this work, you probably heard that it's being referred to at CalHR. The only explanation that comes with level C is for major boards. I would take it as a large board, so.
Which we
yes,
are.
If
Which we
you
are.
speak to your board being a large board with a lot of high-level complexity and sensitivity, as well as other potential political ramifications for
That's
the
us.
decision-making
That's
process,
us.
then
what
you
other
can consider
boards
that.
are at a level C right now?
The Department of Consumer Affairs does not have any board executive officer that currently at that level. The highest level that we have is F.
So the Medical Board of California is F, the Dental
is
Board
correct.
is J.
I once again reiterate a motion for D.
Yeah, because I'm thinking
It's a change of 3 levels from G to D. Yeah, okay. I'm willing to acquiesce for that. I still would make a motion, we go to D. I think it's a realistic level, and it is a difference of 3 levels. So many of us come from backgrounds outside of government, and I think that our experiences are different with regards to compensation and the methods by which it is determined than what most government agencies use. And so, given the fact that there is no C recipient, and given the fact that we're at G. I think going to D is at least realistic.
What would be the downside of going to C? What could happen? What's the negative if we go for C and we don't get it? Do you know?
I don't know. I can't answer that question. I do not know. And again, it's up to the administration. They might deny the whole request or modify it. We do not know. So that's one of the
And
things I
it's
want.
2 years ago,
Greg,
we asked for
it was-
F, and we ended up with G.
Yes.
I mean, 2 years ago, we asked for F, and we ended up with G.
And that was, I think that was,
Is that what
was that
happened?
us, Amy, you and
No,
I,
I
when
think
we
that
asked
was-
for,
We asked for D, we might end up with
Yeah.
E.
Yeah, I think so.
That was Stan.
That was Stan?
yeah, it was me. And again, just one level.
Right,
and-
that's
and
what
we
I'm
got
looking at.
refused. So I just want to be, I just think it's important to
Yeah.
be realistic here.
But things change then, okay? Like I said, we have increase in fee, we have more licensees, and then we also have the supervising inspectors or the assistant director could be making a lot more money than the executive director.
So,
Doesn't make
Nicole,
sense.
can I ask, can we ask next year, during the evaluation period, we could reassess this and ask for another level increase? We can do this annually.
The board can always make the assessment and request and then vote and then request for the exam level increase.
So, and just for clarification, so you can actually request that at any time? It doesn't have to be on an annual basis? I mean, this is the board's, this is you're setting trying to set the salary range for that position. So, I mean, you can come back to it when you need to. The annual review is specific to the human
Got it.
being in the position.
So Nicole, can you tell us, have you experienced other boards requesting salary category changes for their EO description?
The question is that, do you mean like, has that been successful or?
So my first question is, have other boards asked for a change in salary category for their executive officer position?
Yes.
And in your experience of that happening, have they in the past, do they try to go up one level or they try to go up multiple levels?
I started with the Department of Consumer Affairs in my role for about a year and a half.
Okay.
And so during that span, I have the privilege of attending 2 of the exempt salary level increase. I do believe that they only ask for 1 level above on what they currently at.
But they don't have the discrepancy of our supervisor versus the EO, that they don't have that kind of situation.
I agree that they do not have the issues that you are facing, which some other boards are facing as well, which is the assistant executive officer is
Making
have
more
a
money.
higher salary range
So we're
than
different.
the executive officer. Yes, the 2 that I attended in the past did not have that issues of
So-
pharmacy board and some other boards that we have. Second, they do not have the issue of having inspectors and supervising inspectors that are civil service and are making more than the executive officer.
Is our assistant executive officer, is that pay category not G, is that already F?
I think it's under a different category.
Oh, it's in a
Yes,
whole different
yes.
thing, okay.
The executive officer is what we call exempt, exempt from civil service. And for our assistant executive officer, she is a career executive assignment. That's, it's a quasi, it doesn't subject to all civil service, but the salary is set by the California Department of Human Resources. So it's a little bit different than the
I think we should go ahead and request the level that Victor was asking. I think as long we could justify, well, since the 5 year I've been here in this board, I think we pick up a lot of stuff. I mean, we end up doing a lot more things that when I was first came in. So I think it's very justifiable if we could list all the things that we are we have to monitor, and I think last time when I went to governor's office, when I talked to him about pass the budget, the legislation, I explained to him, I say what we've been, what's new to us. And well, I guess he does listen. So I would suggest the main point is that we have to justify why we're asking that level. If we could reason it out, I mean, how can you have a supervising inspector make more than the EO? That doesn't make sense, So
Just to clarify, Albert, we've already done that. I mean, Stan and I did it the year before. Debbie and I just did that as well. So all of the package is really ready, and we submitted it. It was only during that process that we found out that we had to bring it to public session. So that's why we have this right now. The justification's already there. We just need to add on there the level.
So
That's
we
what
didn't, did we submit something in 2016? Because 2015, they denied our F and went to G. What happened in 2016?
I don't believe that this process was done in 2016.
We were not advised by HR that we needed to do this. This is new. We were just told this year.
So she missed out on a couple of years.
So because I reached out to HR, to the director, and then he said we needed to do this.
Yeah, that's why. So we can go on.
So we have a motion on the table, which is from Stan. Is there a second to Stan's?
Now, what is the motion? It's my motion?
No, it was my motion. It was
So
my
are you
motion to
okay
go to
with
D.
seconding it to go to D?
And then, so I need someone to set, because Greg was my
Mr.
second.
Weiser actually seconded.
Okay, so your motion was to go with D.
This is
Stan
D.
seconded it.
Okay.
Okay, so we can take a vote. Is there any public comment to this? Okay, if not, all those in favor to recommend level D, along with all the justification we've already put together, raise your hand.
4, 5.
6. All right, good. Mr. Schad, is your hand up?
Growing in numbers.
Alan, is your hand up?
Good God, yeah.
Well, you gotta put it up, Ellen. You always put it out here like this. It's like you're halfway, you can't quite make up your mind.
Okay, those opposed to the motion, raise your hand. 1, 2, 3. Okay, motion carries.
All right.
So we'll get the package together for you, Nicole, and then we can present it, because it's already ready to go. I think you've already seen it, but we just need to add the level.
All those in favor of giving Nicole a raise?
I know we're going to get along. Thank you.
Thank you very much for coming.
Thank you.
There was an alternative. We can change her title to assistant, and she'd make more money.
Well, I was also thinking we could get rid of the board and then re-put it back together, just like the marijuana board, and sign another salary. Dissolve this board, create a new one.
So, Madam President, are we going to take a break? Or what is the rest of our schedule? Are we going to lunch? Because I've got a checkout issue and all that.
What is
Okay, break.
are we going to order lunch?
I don't have to eat lunch, it's just a matter of scheduling it.
Why don't we just take a 10-minute break?
15 minutes now and go check out.
Let's do a 15-minute break, come back at 11:30, and then we'll continue on.
Could we do about 20 minutes, 25 minutes, as long as we're not?
Yeah,
Yeah,
Okay.
20 minutes.
Grab lunch then, huh?
20 minutes.
Okay.
Cool.
11:35. Yes?
Well, then I better get moving.
See y'all.
Thanks. Okay, we're back on the record. We're going to move on with the Organizational Development Committee report, which is item 12. First item is item A, which is a budget update and report, fund condition report number 1. Attachment 1 contains the fund condition report prepared by the department. The fund condition includes a mid-year augmentation the board received to ensure sufficient funding for continuity and enforcement-related activities through the end of the current fiscal year. It also includes an augment that the board received as a result of an increase in employee compensation as part of a new union contract. Ann, I wanted to ask too, in the months in reserve, I noticed in 2016-17, we went down to 3.5. Is that because the license fees are just starting to kick in?
New license fees took effect July 1. So that's why you'll start to see a slow increase in our fund as we start to collect the additional revenue.
So if you see right now, we're at 3.5 months in reserve. It's expected to be up to almost 5 in 2018-19 as those license fees kick in. Any board member comments on the fund condition report? Public comment. Item 2 is budget for fiscal year 16-17. We just started our fiscal year July 1st of this year. However, the last fiscal year's final numbers won't be ready until the beginning of August, so next week. And then we'll have a final budget report that will be provided at the next meeting. There's some preliminary information that's summarized in the chair report. The board received $20,301,100 in revenue, mostly from licensing. 84% of the income on the revenue was from licensing, and then 10% out of citation fees. Actually, that was, for us to only have 10%, I mean, that's actually not bad. I mean, indicative, the fact that 84% of it is licensing too. And then the board expended approximately $21.3 million, which is 97% of its authorized budget, and the largest expenditure category was on personnel. 16% on enforcement. I'm assuming that's Attorney General fees for the 16%?
Yeah, Attorney General, Office of Administrative Hearings, court reporters, those kinds of things.
And 12% on pro rata, which is an area of ongoing inquiry that we have with the department on how we're spending that money.
So there's 2 types of pro rata included in there. There's statewide pro rata, which are things that we pay for like control agencies, workers' compensation, all of the statewide programs. And then we also pay pro rata to the Department of Consumer Affairs for the centralized services that we receive through them.
Our new fiscal year budget authorized expenditures for this coming year is $22,317,000, and attachment 2 contains the detailed budget charts for the board revenue and expenditures that we just discussed. Any board member comments on the budget for last fiscal year? Public comment. Okay, moving on to item B, which is board member reimbursement information. Attachment 3 contains a summary of all the board members' reimbursements for travel expenses and per diem payments. Board members are paid for a day of a board meeting, but they also can submit hours worked in addition to the board meetings for additional board business. And some board members do not, it's not uncommon for board members to waive per diem payments or only request partial reimbursement of travel expenses, so that's indicative in the chart. There is a newly released member per diem certification form that must be signed by each board member in order to claim the per diem for attending a board or committee meeting. The form requires the member to certify that they are not receiving compensation, including vacation pay, from their regular public employment for the day of the meeting. Is this only for public members, employers?
So, yeah, but we've been advised by the department that this is still a draft and that they're working on refining the process.
So it's not in use yet?
Correct.
So we don't,
Not yet.
Once it's finalized, board staff will have the forms available at the end of each meeting, and will submit the completed form to the department to process per diem payments. And a summary of the board member reimbursement is attachment 3. Board member comments.
Oh,
Sorry, Laura?
after the board member comments, I was just going to say, if we do have any state employees that we may want to have a conversation about the impact that the per diem has individually. We might only have one state employee. No? Okay.
Okay.
Never mind.
Public comment. Okay, item C, board member attendance information. It's listed for this past year. And historically, board member attendance has been part of the org development report. But we, at the request of the board president, this information is now provided at each board meeting, so there's a copy of it. Debbie, you get the gold star at 100% for last year. Yay!
She wasn't here yesterday.
And you missed yesterday. And Victor and I are right behind at 93%, so good. And then there's attachment 4 has all the board member attendance information. Any board member comments? Public comment. Moving on, personnel update. The board currently has one vacancy on the board, and the position's a public member appointment that was formerly held by Greg Murphy, and we're still waiting for appointment. It's for that position. Yes. And then staff updates. We had a board analyst that recently passed, Marcy Stratton. She reviewed some of the sterile compounding applications and renewals, and she was very well liked by the staff, applicants, and licensees. And our condolences to her family for her loss. And there's some recent hires, transfers, and promotions, departments, and recruitments that you can read. Is there anything you want to highlight on there, Ann? Okay. Any comments from the board members on the board update on personnel? Public comment. E, discussion. We already did that on the executive officer. Future board meeting dates. There's a future board meeting date set for November 8th to 9th of this year in Sacramento. And then the 2018 board meeting dates are in the packet as well. Included also our petitioner board meetings that we've set for 2018. So thank you, Ann, for doing that, because now we can plan out for the next year on our meetings. All right, let's move on to discussion and consideration of UCSD's pilot program. I saw you here. Hello, good morning.
We're back.
And this is to permit patients to access medications from an automated drug delivery system not immediately adjacent to the pharmacy. Now, we've had the enforcement committee review your final survey results, or your pilot results, and we're asked to come to the board for full review. And I think this is what you're doing today.
Yes, that is correct. So, good morning, almost afternoon. We're really excited to be here to share the final results of our study that we've had ongoing. First of all, I'm Jan Hirsch from the University of California, San Diego School of Pharmacy. This is Kim Allen, the Director of Pharmacy at Sharp Reese Steely Pharmacy. They're the pharmacy that has implemented the Script Center on the off-site location. We were advised by staff to keep our presentation to 10 or 15 minutes, smile, and then have questions after that. So what I have done is we pulled together an executive summary set of slides, which is a shortened version of the slides that were sent to you. You already have the full version of the slides, and you also have the final report, and you've had those. We've just taken a few slides out of that full PowerPoint, and we'll just summarize. Okay, can you change that? We're going to start with giving you a little bit of information, background, insight into the operation of the kiosk, and we're going to do this. We'd like to take just 2 or 3 minutes to do this because a lot of the questions we had from the enforcement committee were about operation types of things. So we'll talk about that. Then I'll give you the highlights of the study question results, our conclusions, and then at the end, if it's okay with you, if we can delay questions until after we do the presentation. Okay. And we only have about 12 slides. Is that really good? Okay, next. Okay, I'm going to turn it over to Kim to describe.
Hello. So here again is where the kiosk is located at Sharp Memorial Hospital. It's on the first floor lobby, and it has access to both employees and patients. However, the study is only focusing on employees at this time. Even though you can't see it, well, you can see the kiosk, you can see the lockers next to it that we use for large items. In the room, there's a security camera. In addition to the security camera that is in Asteris, the Script Center, that takes a picture every time somebody utilizes it, there's an additional security camera. There's a telephone to the right of the kiosk that allows patients to have access to our pharmacist 24/7. During the day when they dial the number, it goes directly to the pharmacy that supports the kiosk, and after hours it goes to a pharmacist on call who at that time has access to the patient's pharmacy records. We wanted to give you a brief snapshot of the process of dispensing the prescriptions that are going in the kiosk. So the prescription comes into the pharmacy as would any other prescription. It's acknowledged as a kiosk prescription, At the point that after the pharmacist verifies the prescription, as they do every prescription, it's segregated and put off to the side, which allows us to do the input into Asteris Central. And a pharmacist then reconciles what should be going into the kiosk as to what's in the tote. The tote is then secured and transported to the kiosk by pharmacy staff. It's actually a technician. They load the machine. Everything is recorded as to who is loading the machine, what goes into the machine. Once the prescriptions are entered into the kiosk, any patient that requires a consultation is then notified. Well, actually, every patient, when the prescriptions are put into the kiosk, are notified that their prescription is ready for pickup. Those prescriptions that are new, or that the pharmacist feels like, if it's a refill and they feel like they need a consultation, the patient at that point is then notified that they must call the pharmacy prior to having their prescription released. So once the patient receives the notification, they then call the pharmacy and receive their consultation. That allows them to call at their convenience, which might be at their desk, it might be while they're at home, and they actually speak to the pharmacist. At that point, the pharmacist feels like the consultation is complete. They and only the pharmacist can release the prescription to the patient. So a technician has no control. It's just access is only available to the pharmacist. The pharmacist then releases it, and then the patient can pick it up at their convenience. Next slide. So then we wanted to, in our conversation with the executive committee, there were questions on how the kiosk works, and we wanted to make sure with the different technologies approaching the board and the new board members that there was an understanding of exactly how the kiosk functions and how it works. In the video, you'll notice that there is a video consultation available. This is not being used currently at SRS or at Sharp Memorial, but it is an option and it is being used in other states. So I just wanted to bring that to your attention because when you see it, you'll see that there is a video consultation and it is something that we can consider moving forward. So we're going to go ahead and show.
With the audio.
Well, it's me, so I can just talk to it.
The video, the audio was working before.
Hold on just one second.
We checked this.
I think.
Director of Communications and Regulatory Affairs. I'm going to show you a little bit about how Script Center works for express prescription and OTC pickup. The whole process starts in the pharmacy. Prescriptions are filled just as usual. Those prescriptions that are intended for Script Center are put aside once the pharmacist has had an opportunity to verify those prescriptions. The prescriptions are placed inside a Script Center container. Containers come in one of three sizes: a small, a medium, or large. The prescription is scanned, and then the container is scanned. The prescriptions are then securely transported over to Script Center in a secured tote by a pharmacy staff member. The pharmacy staff member logs into Script Center by using their fingerprint. The front doors are unlocked. Prescriptions may be loaded anywhere within Script Center. Script Center's sophisticated barcode technology takes care of finding the correct prescription for the correct patient every time. Now, as a patient, I receive a notification that my prescriptions are ready to be picked up. But if any of my prescriptions require counseling, I'm notified that I must contact the pharmacist and speak with them before I can pick up my prescription. I can contact the pharmacist using my own mobile phone when it's most convenient for me. If I haven't yet contacted the pharmacist and I've traveled to Script Center, I input my unique claim check, along with my birth date, and you can see I haven't called the pharmacist, and therefore my prescription is still on hold. I have another opportunity to contact the pharmacist now. I'm using Script Center's video consult feature to speak with my pharmacist, and you can see the view from the pharmacy on your screen now. Once the counseling session has occurred, the pharmacist can then pull up my patient profile. They can release my prescription remotely. I can then continue on to my shopping cart, where my prescription is now ready. I sign for my prescription, and Script Center also takes a photo of me. The pharmacy has access to many different reports, and here you can see the photo and signature capture example. Script Center tracks all prescriptions at all times, and the pharmacist or pharmacy staff can see that through the Script Center reporting features. I pay for my prescription here using a credit card, debit card, FSA, or even payroll deduction. I pick up my prescription and I'm on my way. Thank you so much for allowing me to show you a little bit more about how Script Center works.
Okay, I think we're done with that. I'm going to now highlight the study results for you, and then we'll be open for questions. And if you can turn it to the results summary. I'll be presenting a summary of the research questions that were asked in the protocol. Okay. First of all, we found that the majority of employees surveyed actually agreed that they would benefit from being able to pick up a prescription at work. They were also agreed that they would be more likely to pick up medications if they had easier access to the prescriptions. And this employee survey was done before the kiosk was actually put into operations. The second question was around kiosk usage. The users of the kiosk were excuse me, fairly evenly divided amongst new prescriptions, refill prescriptions, and OTC medications. The majority of prescriptions meaning new and refill prescriptions, were picked up during pharmacy hours. However, we did, by looking at the kiosk utilization rates, the kiosk was used every hour of the day to pick up a prescription. In a survey of the kiosk users, the majority of kiosk users agreed that their questions had been answered regarding their prescriptions. And if they did have questions, the majority also agreed that they knew how to contact the pharmacist. All right, next slide, please. Yeah. The more detailed questions were related to the kiosk versus the regular counter operations. The kiosk versus the regular counter, we saw no differences in two aspects. One of those was the return to stock rate, and one of those was pharmacist assessment of their ability to counsel. And I will show you a little bit of data on these two. Next slide, please. Okay. If you, this is the regular counter versus the kiosk. If you look at the bottom line, the bottom row, that's the kiosk, and the total prescriptions filled for the kiosk were 943. 893 of those were picked up. Therefore, total of 50 were returned to stock. All right. The thing to look at is the last column, which is the mean or the average monthly return to stock rate. There's a return to stock rate every month, and we took the average of that. And that's what we compared between the kiosk and the regular counter. So if you look at the top row of data, that's the regular counter 6 months prior to when the kiosk started operations, and we saw a mean monthly return to stock rate of 5.2%. And then we also compared the kiosk rate to the regular counter during the same study period time. The return to stock rate, the mean was 5.3% then, and we compared those to the mean return to stock rate for the kiosk, which was 5, and there was no significant difference in those means. We had hypothesized that the return to stock rate for the kiosk would be lower, but that was not supported by our data. And the next slide. The next slide shows the pharmacist assessment of their ability to counsel, where we also saw no differences. We asked each pharmacist after their counseling session, rated these 3 parameters: their ability to build a therapeutic relationship with the patient, establish a management plan, and negotiate safety net strategies. And those are the 3 graphs you see. The pharmacists could indicate they were able all the way to they were not able to perform this. And if you look at the pattern is on each one of these, the pharmacist indicated they were able to perform each one of these or establish these. And the pattern did not differ appreciably at all between the counter and the kiosk. Next slide, please. So that's where we saw no differences. The second part of this slide is where we did see differences. So we saw differences in the mean time to pick up of about 1 day greater in the kiosk versus the regular counter. And then we did see some differences between the percentage of consultations in which the patient said they had no more questions after the consultations. And I'll show you the data for these quickly. So here is the time from when the pharmacist verified the prescription to the pickup. On the counter, the regular counter versus the kiosk, we compared the days, and it was also broken down to hours, and you can see the range. But if you focus on the days, for the regular counter, it was 1.8 days. That was the mean time to pick up. For the kiosk, it was 3.0. So the mean time was greater for the kiosk than the regular counter, of about a day.
Is more convenient or less convenient?
I don't think I can answer that based on these data.
Okay.
There's a difference in the way they pick it up, yes.
Why are the plus or minus amounts so different with the kiosk versus
The plus or minuses are the standard deviations of those means.
Okay.
Yeah, which just indicates the variance in the data, and those are fairly small standard deviations. So I would focus on the mean differences, 1.8 days versus 3 days. And then the standard deviation gives you an idea of the variance of that data. Yeah. We worry if we see standard deviations that are bigger than the mean. That would be like a lot of variation. These are pretty small.
Got it. Thank you.
Okay. Next slide. Did the patients have questions at the end of the consultation? They have the counter versus the kiosk, and if you look at the yes row for the counter, we had 51 patients out of the 151, so that was about 34% of those patients said, yes, I have a question at the end of the consultation. It was lower at the kiosk, where we saw only about 19% of those patients said, yes, I have a question at the end of the consultation. So fewer patients had additional questions after the consultation at the kiosk versus the counter. And then finally, the types of questions that were answered and the number. Of those patients that did have a question, the average number of questions at the regular counter and the kiosk was 1.1. And the types of questions there were at the regular counter, all of those were drug-related questions. And at the kiosk, we saw the majority were drug-related, but we did have general pharmacy and kiosk operation questions also at the kiosk. Next slide. So our conclusions are, as you read in the study report also, we think the kiosk was a convenient, safe extension of the Sharp Reese Steely pharmacy, and we saw similar pickup and consultation. The clinical significance, however, we should point out, of the differences that we saw in the time to pick up that I just showed you, and the patients that had no more questions, we can't determine what that clinical significance is based on study data. We did not study that. Patients were satisfied with their access to the pharmacist and also satisfied with the kiosk operations. There have been no complaints about the kiosk to Sharp Reese Sealy and to the board, as far as I know. I think, very importantly, the pharmacists agreed that their ability to counsel the kiosk patients was similar to that at the regular counter. And of note, the pharmacists that were doing the counseling were counseling for kiosk and regular counter patients. The fact that we see usage continue for the kiosk, even after our study enrollment has been closed, is really another indication that we think that the kiosk offers an additional option for patients to pick up their prescriptions. Next slide. So as far as next steps, what we would like to request is we'd like to continue to operate the kiosk at Sharp Memorial Hospital as we have been doing. We would propose that we would continue the study of the kiosk and give the board regular updates of that. We would propose that we look at the return to stock rate at the kiosk, the time to pick up at the kiosk, and also patient satisfaction at the kiosk. And notably, please, I want you to understand, I'm saying that we would be following the kiosk. We would not necessarily be continuing comparisons to the regular counter because those, it's very labor intensive, et cetera, and we didn't see, in our opinion, appreciable differences. Then we would like the board to consider amending 1713 to include all prescriptions and to be allowed for the script center to be allowed to be placed away from the pharmacy. And we have provided on the next slide, that I'll go to a moment, some ideas for recommendations that we have based on the operations that at Sharp Memorial Hospital, some of the best practices. And we would like to work with the Board of Pharmacy over the next 3 months to see how we could work with you to help you amend 1713. And then also importantly, we would like to go ahead and pursue publication of these results that we have so far. And with that, I'm not going to go through these recommendations, but these are the types of things we would like to discuss with you in amending 1713. So questions? I think we're to the questions slide.
I was actually, I think, surprised that people delayed picking up their medication. Because I actually thought by making it more convenient at the work site that they would pick it up faster. Because I was actually thinking this was going to be like one of the things you're going to come out with is maybe better adherence and compliance. And so I'm surprised that, are you, and do you have any thoughts on that?
So a lot of it is speculation and having
Right.
conversations with the pharmacists and the team. As far as return to stock, I agree. It was a little surprising. However, it's hard to say why. I don't think it's unusual because the trend is, regardless, is that patients don't pick up their prescriptions. I mean, it's something we deal with on a regular basis as far as whether you're making multiple calls to patients. Yes, so I was surprised and I don't have an answer.
I mean, I
as
guess
to
I was,
why.
the return to stock was pretty much equal, so.
Yeah.
But I was surprised that they waited a day. I thought it would be more convenient and they would go pick it up sooner.
That was
Well-
versus you as well.
Yes, so I think what I kind of think, I agree in some in certain aspects. And one of the things that we did look at was therapeutic class, and we had broken that out. However, the data was very small, but what would be interesting moving forward to be look at maybe what was the class of drug. If it's an antibiotic, was it picked up sooner? We don't have that level of detail, but I also think that patients are able to call at their convenience. They might have called, on Monday, and in the pharmacy, you have to get there before the end of the business. Here you had more time. You could pick it up on the weekends, you could pick it up in the middle of the night, you could pick it up in the evening before, when the pharmacy was closed. I think there was more flexibility in allowing the patient to pick it up when it worked for them and not necessarily when it was convenient for the pharmacy. That would be my guess.
Another thing could be, these are employees at the hospital.
Mhm.
So perhaps they weren't working that day.
Absolutely.
You know, and the prescription came in on a weekend, and that happens to be further away from their house than the actual pharmacy or whatever.
Absolutely.
So-
It could have been, there's many ideas. I don't think it's a bad thing. Again, I think it's open for speculation.
But as I recall, your anticipated usage was much greater than your actual usage. Is that correct?
Yes.
Okay.
And I have discussed at past meetings that there are barriers to getting patients, employees to use the machine that we deal with on a daily basis.
You think it's related to public relations and them knowing that it's available or not?
I think that's part of it. I think it's part of it is patients understanding that they don't have to be part of Sharp Breeze Steely to use our pharmacy, which is our biggest barrier for patients to use our pharmacy. They kind of think because of the name that we're closed and that you have to be a member or a patient of our medical group
Got it.
as opposed to an employee or anybody in the community can use our pharmacy.
I'm sorry, I did not catch it. Do you have the breakdown of all the new prescription, that means new use for the patient versus the refill, chronic maintenance drug? Do you have the
So-
breakdown?
Yeah. Do we have the breakdown
Yeah.
in our data?
Yeah. New prescription versus refills?
I think it's on page
Yeah, I think it
48
was-
of the handout. Is that the during versus after hours pickup for the study period?
Yeah.
I think it's page 48. So I was just looking at the totals. Is it 1484, the total?
1480, there were 1,484 total pickups. Of that, 474 were new prescriptions, 426 were refills, and 584 were OTCs. So they were fairly evenly divided.
Can I ask a question? What is your definition of a new prescription for purposes of the study?
So, we looked at, and it was a challenge because Asteris looks at every new prescription number as a new prescription. However,
Right.
if you look at the
Could be a
definition of the
refill.
law, and what we did for consultation was for any new prescription under the law, which is any new dose, new physician, new drug is considered a new prescription if it's new to the patient and to the pharmacy. So when we get electronic prescriptions to come through, we give it a new prescription number for refills because that's the way the system works, but those are not necessarily new prescriptions because the patient's been on that medication. Does that answer it's a little?
So can I ask a follow-up question on that?
Yes.
So under the current regulation, you can use one of these devices under certain criteria. One of the certain criteria is that it's a previously dispensed medication. So what I'm curious to know is, of those that are categorized for purposes of your study as a new prescription, how many of those were actually previously dispensed?
We don't have that data today. I don't think we can actually, we'd have to go back and ask Rami. I don't know if you can do that.
I can kind of tell you. Sharp Breeze Steely did not do a consultation on one that was rewritten. So you can tell by the number of consultations that it was in fact a new prescription that the patient had not previously taken. So if you look at the number of consultations, you can get to that number.
So if there was
Does
a
that make sense?
renewal, let's say the patient was on benazepril, and they got a renewal, the doctor just wrote a new prescription continuing the same dose. The patient was counseled or not?
If it was it depends on if they were counseled. Well, if it was new to our pharmacy, they were counseled. If the patient had been on the benazepril in our pharmacy for the last year and the prescription came across that way, they were not counseled. We consider it a refill. If everything is exactly the same.
Is that consistent with the law?
Well, so I think that it would be probably helpful to, I don't I'm not trying to drive anything here, but I think it would be helpful for the board to know which are the previously dispensed medications, because that's what the law currently affords. And so when you're looking at changes in, or when you're considering changes to the law, understanding the expansion of new prescriptions and whether or not that's appropriate, it might be helpful to have a segment of the study focused in that area so that you can understand whether or not there's correlation specific to patient care in that area.
Well, you can assume, we look at the same, we use the law as our consultation. So.
But when you're looking at like pickup times, because it looks like over weekends it was mostly OTC, not prescription. So breaking it out so that the new prescriptions truly are the new prescriptions versus the refill prescriptions. Because if you're looking at expanding the automated drug systems to include new prescriptions, which currently is not allowed under the law, it is allowed under the study, but not under the law. It seems like that might be helpful information for the board as they're debating whether or not that's an appropriate change.
I'm sorry. What you guys are saying is there's a subset of these new prescriptions that you would not necessarily consider they are new.
Yeah, so under the provisions of 1713, one of the allowances for using the device is for a previously dispensed medication. And so I'm having a hard time reconciling those two numbers.
Yeah, and I don't think we did not collect that to see which ones had been previously dispensed. I don't have that information at all in the database.
And also, the primary purpose of your pilot study is to help the employee of the hospital so they could pick up the prescription issues. But then I look at the statistic, you only have about 8% of the employees who sign up for the whole program. So what are the challenges that you could convince them of helping them and then they're not responding at all?
Well, a part of it is whether they read their email or not, whether they're at, because we send out blast emails letting them know about the program. We went to huddles, trying to convince them. Again, a portion of those patients that are included in the study data that you're looking at are maybe not on campus. So we have 4 hospitals within the campus range, and Memorial is just one of those hospitals. So whether or not that is convenient, when we started the study, we sent the blast out to everybody to get input, not knowing what that.
Because I would think you see a need for that before you go into a study, right? I mean, but when you don't see the need, I mean, you go into it. If I could recommend something, okay. I would really highly recommend you do a pilot program on some of the rural area that people are talking about, even telepharmacy. Some area nobody even there exists. If you put in one of these and do a study and come back and say how you help out the community of a rural area when they have no access to a real pharmacy, and that would be really beneficial to the patient, the profession, and also to the public safety.
I'd like to just probably underscore some of what Victor's thoughts are. Given the fact that the response has been less than what you have expected to utilization of the dispensing machine, and given the fact that the pickup time for the prescriptions has been a day longer than what you might find in the traditional pharmacy, I think it was about a day longer, and the fact that the return to stock is even greater, so.
No, it was equal.
It's the same.
About the same.
It was the same.
Yeah, but given, where you are, and I realize that, blast emails are, have you considered the fact that maybe this isn't the panacea that perhaps it was thought it might turn out to be for the employees, or that this isn't it? I mean, has that anybody thought, well, maybe we're barking up a tree that isn't going to give us any results here, and part of a study would be you conclude either yes or no, and it seems to me you're hesitant to give it a negative thought.
Can I ask a question before you answer that? Is it the profile, the patient information, is it accessible to the employer?
To their employer.
No.
No, right?
No.
I mean, if it's access to employer, that's why they discourage from using it. That's-
Oh, well, you know, that is a perception. We have, you know, but I don't think that's unique to our setting. I mean, we have a patient portal that I know employees won't use because they're afraid that the employer has information. But absolutely.
If the perception is true.
Is this, you know, you asked the question, is this the panacea? There are some surprises by the study. Would we know, we really were limited in what we could do because of the limitations by the board in making it be part of the study, right? Where we could put the machine.
Perception.
You know, there are some surprises. Do I think that it's a negative? I don't think so. I think if we were allowed to move forward and to expand who's able to use the machine, you know, we limited it to employees for reasons as far as just doing this study. But no, I think there's absolutely a benefit to having this machine.
It seems to me there's no downside to the public by doing this. I mean, the question that I would have is, you know, if you're willing to put out the money to make this happen, I mean, I can't see where it's economical for you to do it, but it would seem that, you know, it would, you know, whoever uses it would be happy to use it, and I don't see any real downside to the consumer to have it there.
Can I say
So-
one thing about the utilization piece? I just wanted it to be clear. Part of the study was not to assess demand or utilization. In fact, we were only looking for a set number of events.
Okay.
So yes, there is perhaps a lesser uptake, but the study was not designed to assess demand.
Right.
That would have been a
Well,
different study.
I also think that we put a limitation on this. I mean, I actually think that these kiosks are a thing of the future, and we
Yeah,
need to
I-
embrace it and figure it out. And
I
I
do
think
too.
we put some handcuffs on them because we told them they had to put the machine right next to the pharmacy. So, you know, in the back of my mind, I'm wondering, well, so the person can either, you know, pick up the medication out of the kiosk right next to the pharmacy, or they can just walk into the pharmacy. So I think one of the things they're asking for is, let us put the machine someplace where maybe it's helpful, like in another building where there's no pharmacy, and then maybe we'll actually see what we, then
Exactly.
maybe we'll
That-
find out some information.
That's
So
what I had to say. yeah.
I think that's what we should play with. I mean, I think, I shouldn't say the word play because I'm a professional. But I think, you know, that maybe we need to, instead of, you know, grinding this thing into the ground, let's, you know, there's reasons why having a kiosk next to a pharmacy might be advantageous, and we've kind of played with it a little bit. But maybe we should, like, let's think outside the box here.
Yeah,
And
I-
let's, so what, some of your questions, let's see if maybe we can't, like, get beyond this and look at some of your questions and getting it, like, into that other building where maybe actually people will pick up prescriptions they
Well,
want it. And
I think
Again,
it
there's
was a
no-
good place to start anyway. I
Yeah.
think where you guys started, I think it was a
Yeah.
good place to start to
Yeah,
get
I agree with that.
some of the results that you got, the fact of, you know, there's no, because of the return to stock, the fact that the consultation, it sounded like a lot of patients may have felt better talking on the phone or asking more questions or something like that. So it sounds like you have some results that can be worked with to expand on this.
Yeah, exactly,
Yeah.
Cheryl, I agree with you.
Well, it is more, you know, it's from a standpoint of people that don't want other people hearing their consultation. It's a whole lot better to do it this way.
Well-
The other thing is, like I said before, I don't see any downside,
Yeah.
any problem that it causes, and I, for one, would use it because whenever I want to pick up a prescription, the place is closed. So, you know, it's just convenient hours.
I agree with Debbie that I suggest you guys should try another location that have nothing affiliated with the university.
Well, I think we have to give them that.
I think that may be give you a little more information because
Is that your
I mean
request?
I'm pretty sure the employee don't like the employee to know what they are taking. So
So,
the
Amy-
perception is, you know.
Do we need to have them come back to us with the proposal for a kiosk offsite?
Yes.
Isn't that what
That's what
Is-
they're.
and that's what you're gonna recommend.
That's what they've asked for.
Yes.
We've asked to have 1713 amended to
Right.
allow it to be away from a pharmacy.
But we
and
can't
with new
amend it, we can't amend it. Can we give them another waiver? Laura, can we give them a waiver to do a pilot with the machine offsite?
No, let me understand. Are you asking to extend the current
Yes.
waiver, or are you asking to place it in another location, or
Oh,
add
no.
another machine, or?
Well, no,
Both.
we would we would like to continue using the machine.
Mm-hmm.
And we are willing to continue, I think part of the issue is that we need to continue with the study to be able to continue to use the machine. So we would like to continue the study, the kiosk alone. And as we are attempting to amend 1713, because I think that is what you need to do, is to make the amendment.
The licensing committee was talking about 1713, and we're kind of looking at that as being an agenda item coming up. And just so the board knows what 1713 is, and I'm not implying that nobody knows, but it provides the authority for a pharmacy to use an automated drug delivery machine under specified condition, and subsection D5 establishes the requirement for such a pharmacy using an automated drug delivery system to provide an immediate consultation with the pharmacist, either in person or by telephone, upon the requirements of a patient. So what are you thinking of tinkering with that?
Well, we would like to be able to have new prescriptions in the kiosk, because today you can only have previously dispensed prescriptions in the kiosk. So we would like to have new prescriptions in the kiosk. And then we would like to have it so that it states that it's not adjacent to a pharmacy or not.
But right now, in the last year, do you have it right adjacent to the pharmacy for the last 2 years?
No, we do not.
Yeah,
So
that's-
where
that
do
was
you
what-
have it now?
We have it at the
In the lobby, right?
in the lobby.
Yeah, so it's
Debbie-
not adjacent to a pharmacy.
Yeah. But Debbie, it was your impression, I thought, that it was next to the pharmacy, and it's not.
Oh, it's in the building.
It's
It's
in the
in the lobby,
hospital.
right.
So
Yeah,
the
it's-
hospital does not have a retail pharmacy.
Yeah, so.
It's a different building.
Okay.
And I think, Stan, I think the licensing committee is looking at 1713 in terms of the consultation piece.
Consultation.
Because the enforcement committee's been actually managing
Right.
this whole pilot, and they felt that, the enforcement committee felt this needs to go before the full board. I mean, we have a lot of examples right now that we have medications stored in automated devices that are not in the pharmacy. I mean, look at all the Pyxis machines that we've got all over the place that are currently on, that we're trying to get a handle on. I mean, it's just the wave of the future that's going to occur. I agree with Debbie. So I think we just need to have some process. I think right now your issue is you need to have the waiver extended so that you can continue to operate. Because at this point, the waiver waiver timeline is complete, right?
Correct.
So I think that's the immediate request.
Yeah, my question was whether, I mean, I didn't know what they wanted to change in 1713.
Oh, it's on, actually, I think they gave us some drafts on their presentation. Is it on page 81?
Highlighted.
Yeah, of the handout.
Okay, was that in the,
Yeah, it's in the packet.
So as to that, I didn't capture that either in the
Yeah, I didn't
summaries,
either.
but I do think that if that's what the committee is, or excuse me, the board is considering, I think that needs to be a separate agenda item at a future meeting. I don't think your agenda item covers that particular piece.
So is the study, the concern I have, is the study going on right now? Because if they've complete, does this mean they have to?
So, and actually, I don't have in front of me the materials that, upon which the original waiver was based pursuant to the regulation, and I think we would need to look at that, and if we can take a break, I don't know if those documents are available electronically or not, but we can look at that and see, but about whether or not the board could today authorize an extension.
Now,
or
I'm
not,
looking,
but
I'm looking, Laura, on slide 79. They do state on there, I mean, this is material we got, to continue kiosk operation, continue to study the kiosk and update Board of Pharmacy. So the request was on the material that was provided to the board.
I looked at the summary and I didn't see.
It's on 79, page 79 of the handout.
page 79?
Yeah, it's over 94 pages. It's right after the Sharps 10 key best practices.
I only go up to 61.
Of the long one. Because you don't have the appendices. The appendices have
Okay.
to be set separately, and I think what you were looking at.
Okay. So
I got this from the board website, is what I just
Okay.
downloaded.
So the appendices came when?
That's when we handed them out yesterday, Steve.
Ah.
Yep.
Oh,
Yep.
okay. But it's also.
It was
that
posted on the
language-
Well,
board.
in here, I've got them in here
The language is
someplace.
also in the PowerPoint, the long PowerPoint you have. And on the slide 40, does that say 6?
Yes.
Well,
Slide 46.
so regardless of whether or not it's, the language is actually in the materials, the discussion of amending 1713 is not one appropriate for this particular agenda item. So the only issue is really the study. And I would just need to kind of evaluate the original request and grant to see whether or not if the board could
Because
extend.
I think that's the most urgent issue right now pending is the continuation of this, because I think you're right, and I don't think there was a plan to amend 1713 today.
No, to be clear, what we are requesting, yes, to continue to use the kiosk. We propose we will continue to study the kiosk. Secondly, we are requesting to work with the board in the next 3 months, whichever group that might be, to help you with some of these recommendations that we have based on the utilization.
So I'm
So we are
envisioning,
asking
Laura,
this-
that I'd go back to the enforcement committee to work on the draft language.
Well, I think, so in draft language in order to amend the regulation to allow this kind of
Yes.
kiosk for the future,
Without a
yes.
study.
Yes.
So the challenge there and what I'm concerned about and that I want to look at is whether or not now that you've provided a study, that the waiver provision that allows us to waive 1713 is to obtain a study. And right now, we have the study that you performed, and so the question is,
Right.
Can we continue
Right.
this?
right,
Right.
but if you've provided the deliverable that you originally proposed, I need to look at what the board did in its prior action in order to give a better advice on that. I'm sorry, I don't have an
That's
immediate
fine.
answer.
Are you using 340B drugs in this?
So we are a contract pharmacy for a 340B entity. So there is a possibility that there's 340B drugs in there, but it isn't part of our, it would be retrospective of, we don't know until after whether or not the prescription qualifies. if it's-
I'm just asking because that actually would provide some financial, the way for it to fund
Absolutely.
this.
So part of our,
Right.
part of our future use would be to use it for discharge prescriptions,
Mhm.
to actually have patients utilize
Mhm.
the kiosk, which
Got
would
it.
be a much greater value.
For hospital discharge patients?
Mhm.
I got Mark about that.
So do you want to
Why?
take a break? Can we go on to the next item and then come back to this, Laura, so that we don't
That's
lose
another
time?
topic.
Yes,
Okay, to give you a chance to look at it.
yeah.
Okay,
We-
board members, any other quick, Laura's going to look at our options to see what we can do today, and then we can continue this after she has a chance to do that. Okay, is there any any further board member comments?
Well, just to clarify, what you're asking for today, forget the 1713, but what you're asking for today is to extend your current
So they don't have to take it down.
right, to extend your pilot.
And presumably also to extend or revise a study?
Yes, let's be clear about that. We also are saying, yes, extend the operation. We will continue to study the operation of the kiosk, not the regular counter. And the study we just did was regular counter versus the kiosk.
So it'd be a new study.
No, it could be an amendment to the IRB. All they would have to do is an amendment, and it would be, yeah.
And can I just understand why you wouldn't want to bring in the regular counter as a control?
Well, we have done that, and it's extremely labor intensive.
Okay.
Very labor intensive. But I'm not even
Can
living there.
I just want to speak on behalf of Asteris for a minute, because the only reason that we are saying that we will extend the study is because we don't want to shut it down. I want it to be clear, we're not sitting here saying, yes, please, we want to put hundreds of more hours into doing this study. But it is our understanding that we can't keep the kiosk operational without having a study going. So that's why we're looking to you for options on how to do this, because if we can't amend the regulation the same day that we stop the study, that's impossible. So what do we do in the interim?
So I'm
during
going to
this?
just say to the board, evaluate whether or not you think additional study is necessary so that you can make an informed decision, because that's what the regulation affords you the opportunity to do. So if they are indicating that they want to continue the study for purposes of additional data collection that you will then be using to help form your opinion on whether or not a regulation needs to be changed, absolutely appropriate, and would encourage you to make a decision based on that if you believe from a policy standpoint that is necessary information for you.
And right now, approximately 40% of the use per the numbers has been OTC. So 40% of the use of the machine has basically been over the counter. So it's basically served as a vending machine in 40% of the cases. 60% are prescriptions.
Of the events, the release events
Yeah,
have
okay.
been more, 40% OTC and about 30 new and refill.
I still don't think you can downplay the use, the 60% of patients that are using the kiosk for prescriptions, regardless of.
No, and that wasn't where I was going with this.
Okay,
I'm just,
'cause that seems
I'm
to
just
be
saying
the-
that 60% of it has been prescription. Would it be worthwhile to look at some larger numbers with the new study to maybe even involve patient use? Because it's just been employees, right?
It's just been employees, yes.
So that might be a new study. I mean, to consider one, you were talking about discharge,
Right.
something where patients would actually interact with it rather than just the employees. I'm just throwing out ideas.
Yeah, I think also getting some additional data specific to the truly new versus the previously dispensed might be helpful, because that I think might be one of the ultimate asks is, do we need to be expanding there?
I think we.
Kim thinks she can ask her IT to do
Yeah,
that.
I have to check with IT.
What does-
Pulling data out of
Yeah.
a pharmacy system is no small feat.
And can I just ask you about the OTCs? Were those OTCs that were on prescription?
No.
So they were just OTCs being recommended by the prescriber, or?
No, it's just access to, actually, you know, it's a great way, it's an additional service, but it allows, that was part of our, when we would market it or be out there, you know, detailing our employees, you know, if you're not sure about the kiosk, you don't know what we're really talking about, go down, purchase an OTC, get a feel for it, hands-on, easy way to get comfortable with the machine, to see if they want to put their prescriptions in it. And you know, I think there's value to that, but I think really the patient feedback is patients are really happy with the
Yeah.
machine. I think the challenge is stopping the machine now. And, you know.
Well, I
it's
mean, I
gonna
don't
be
see a
challenge.
bad thing about having OTCs in there. I thought maybe the pharmacist was triaging, and they were calling the pharmacist and saying, I have a cough, and listen, I'll put some Robitussin DM in there, pick it up.
That could, you know, that could be, and we didn't study that, and I'd have
Okay.
to go back to the staff pharmacist.
But it sounds
to
like
see
you
if they
did
had a
kind of
conversation.
encourage using OTCs as a way to
Absolutely.
get comfortable with the machine. So
Absolutely.
that probably isn't a accurate measure of what reality is.
Right.
Mm-hmm. Okay, so we're going to have Laura
Yeah,
take a look at it.
I'm looking now. Just out of curiosity, has the IRB already been extended?
I have, yes, I just sent in the renewal. They have not approved it yet, but I've just sent in the renewal. It expires in August, no, I think it's September something. But I have to submit it like 45 days ahead of time.
And do you have copies of that with you?
No, I do not. I don't have the final approval.
But
I
it's
can
still-
provide the
it's current.
submission. It's still current.
Thanks.
Kim?
Go ahead and.
Can I make one?
Proceed.
It's kind of a request, I think. If we're going, because I hear we're going down, yes, we will continue to study this, yes. There are lots of study questions we could do. There are tons of study questions, but I would hate to go down, and I'm willing to participate and study because that's what we do. That's cool. But this is a lot of work hours, et cetera. If we're going to do something new, can we hone it to the questions you guys really want? Because I think I have felt like every time I've been up here, I'm not giving you what you want. Although I thought I was to begin with. So.
No, I was just going to, Kim, the whole issue about discharge meds from acute facilities. Yesterday, we had a long discussion, and Rita Shane was here from Cedars, talking about discharge meds at acute facilities. So it was a huge topic. There were a lot of issues about it, and a lot of issues about consultation regarding this. So that's why I made the remark that I did, but I wanted you to at least know where it was coming from.
And I just want to remind you that every new prescription that was in the kiosk was consulted by a pharmacist. And I would continue to make that mandatory. Well, it's the law, first off, but that is something that we do, and we see the value as a pharmacy, and we understand. So I would assume it would carry over.
Okay, so we're going to come back to this after Laura has a chance to review.
Thank you.
Okay, so is there any public comment before we move on to the next agenda? And we'll come back.
Oh, I have no mic. Scott Flaherty from Scripps Health. Just wanted to say that we're very interested in the pilot study. We have 3 ambulatory pharmacies, and we want to expand that footprint. In our health system, we have multi-building campuses. We have many clinics outside of those campuses, and we want to be able to serve those patients as much as possible as well. That's it.
Thank you.
Thank you.
That was fly.
Wasn't raising the hand.
Wasn't a question.
I'm here at confession, and no, first thing, my name is Mark Curry. I'm with the Stairs too. First of all, in a few months, I have my annual salary review. I'd like to invite you all to come. You guys did a
Are
great
you
job.
sure we think as highly of you as we do of our EO?
Anyway, just to give a global perspective of Asteris and Scripps Center. First of all, I want to thank this board. This board I've been coming to this board now since 2009 on behalf of Asteris, and you got to be tired of looking at my face. But you forced us as an organization to change. You forced us to look at things that we didn't consider. This study was something we never planned on 4 years ago in looking at what we are doing and what product we're trying to develop. But because of what you've caused us to do, we've had to grow within as an organization, and our technology has had to grow and forced us to grow. And because of that, other states have taken on Asteris in a big way. We have organizations like Vanderbilt, the Mayo Clinic, the Cleveland Clinic, Baylor, Rush Presbyterian, large organizations who not only bought one, but have bought many, because of what they've been able to do and see and use with Scripps Center. So it's not just California, it's many other states in this country. But more than that, since I've been very limited in scope on what I can do here in California, it's forced me to go other places. And because of that, we've gone to the Department of Defense, and we had to go through so much intricate detail. It's nothing compared to the California State Board. Oh my goodness, it was incredible. But because of the work that we've done here, the DoD has now contracted with Asteris. So now we provide our Scripps Centers to Air Force bases all over the world, and the Army as well. And for any of you who live up in Sacramento area, I'd be happy to host you at Travis or at Beale Air Force Base. Anybody down here, I'd be happy to host you and see a Scripps Center at LA Air Force Base and talk to the military men and women who use our technology there. So with that, I just want to give a global perspective of who we are and what we're doing. So you can just kind of consider that in your considerations. Thank you.
Thanks, Mark. All right, we'll move on to the next agenda item. Thank you both. This is, I think, do we have anyone here from the Department of Consumer Affairs? Okay, if not, we'll move on to agenda item 15, discussion and consideration of the proposed regulation to amend Title 16 CCR Section 1749 related to fees. And to address the structural imbalance in the board's budget, the board worked with DCA on a fee analysis where the department determined the cost of the board incurs to provide various services. The results we included in our sunset report, as well as served as a baseline for development of legislative proposal to recast the board's fees. The proposal was included in Senate Bill 1039 Hill, and it was signed by the governor on September 29th of 2016. And the effective date was July 1st, 2017. In addition to the statute, the board's fees are specified in Title 16 CCR Section 1749. This regulatory change is necessary to provide the board's regulated public with a clear understanding of the fees that will be assessed for the various services, including application and renewal, as well as delinquent fees. At our October 2016 board meeting, the board approved proposed text to amend 16 CCR Section 1749 related to the board fee schedule. The 45-day comment began on April 14th of this year and ended on May 30th. The board received one comment during the open comment period, and that is in the board packet. An attachment is attached to this, which has the regulation text as noticed by the board on April 14th, as well as the one comment that we received on here. And I'm trying to find, do you know, Ann, what the comment, or one comment was?
The comment spoke to the increase in the pharmacist fees versus the technicians, and I believe the quote from the comment was along the lines of, why are you increasing pharmacy technician fees like you are, that pharmacists should be shouldering those additional costs. And if I may continue, the board staff were recommending that you reject that. Actually, because the way that the statute is written, it establishes statutory minimums and statutory maximum fees. And for the majority of the fees that are being established through the regulation, it's setting them at their statutory minimums. So you couldn't go any lower on a pharmacy technician, even if you wanted to entertain it.
So the staff recommendation is to adopt the regulation language as noticed on April 14th and delegate to the executive officer the authority to make technical or non-substantive changes as may be required by control agency to complete the rulemaking file. Board member comments, motions?
Are you doing that as a motion?
I'm asking for a motion.
But Ann, there are a couple of instances that the renewal fee is higher than the initial fee. What are the rationale for that?
That's set in statute. And so just taking a step back, as a precursor to pursuing the statutory changes, we worked with the Department of Consumer Affairs and we did a fee analysis. And Board Member Lippy did a wonderful job helping us through this process and assessing and validating the work that the department did. And so it was based on the recommendations of the department that this board reviewed what they thought that the new fee schedule should be. And through that, then you pursued a fee increase through statute. So the policy with respect to what the application fees should be and the statutory minimums and maximums was set by the board in advance of us pursuing legislation. Okay. So now what this regulation does is it provides clarity to people as to, because the range is, I don't know, $300 to $500, for example, someone might not know, where do I fall in that range? So then the regulation gives them the specific, oh, it's $300.
Amy, I would make the motion.
Okay. Per the staff recommendation?
Yes, I would.
Is there a second? Second from
and
Stan?
Victor, I would also, I remember back when we were going through the fee structure, and we had Consumer Affairs, I don't remember what department it was, but they looked at the actual effort it took our staff to do the licensing, and they actually found that quite often it was more expensive to do a renewal because there was more investigation, there was issues that came up, I don't remember really all the little bullet points, but it was actually a little bit more expensive for our staff to do a renewal application than in some cases the initial application, and that's why we went with the structure that we got in the legislation.
I'm just curious to ask that because it's only for certain classes, but not for all of them.
Well, and if you remember, we did it totally by their space and movement studies. So there were certain situations where, you know, and it might be the technicians, where truly looking at historic and effort, that's why. So we didn't, you know, just, you know, make these things up. We used some really smart people to go and look at it and advise us, this is how you guys should do it based on the efforts that are made by our board staff.
Okay, we have a motion, we have a second. Public comment? All board members to support the motion, raise your hand. Is that unanimous? Cheryl's not. Record will show that Cheryl's not here. Okay, moving on to the next item, which is the discussion and consideration of proposed regulations to add Title 16 CCR Section 1715.65 related to inventory reconciliation report of controlled substances. At the July board meeting about a year ago, the board approved text to add 1715.65 of Title 16 CCR related to inventory reconciliation reporting. At the January meeting of this year, following a 45-day and 15-day comment period, the board returned the regulation to the Enforcement Committee for further review and discussion. That discussion took place in April of 2017. At the took place in May 2017 board meeting, the board approved a modified regulation text and initiated a second 15-day comment period, which ended on May 31st of this year. The board received several comments during this comment period. At the meeting today, the board will have the opportunity to discuss the regulation, the comments received, and determine what course of action it wishes to pursue.
Madam President?
Yes.
I would make a motion that we adopt the regulation language as approved at our May 2017 board meeting and delegate to the executive officer the authority to make the technical, non-substantive changes.
Second.
Did you say
Second by
thank you?
Greg. And before we vote on that, I just wanted to have Ann, the comments we received, what is the staff recommendation is basically to reject all?
Yeah, our recommendation is to reject all, and if there's any specific ones that you're curious about, I'm happy to explain why. A lot of them were outside of the scope of the comment period. Some of them, people were offering language that we felt was not necessary to include.
So I have a question, because I remember it being discussed, and I thought we were kind of rolling with it, and it's the perpetual inventory thing that a lot of the community chains do. And I thought we had, and I think there was a letter that one or two letters that came through that pointed it out, but I thought we had asked the staff, I thought the board we were okay with perpetual inventory being included in the language, and I thought we had the staff was going to kind of make a modification. So I'm curious because I think there were comments. So that's a comment I would like for you to comment on.
Go ahead.
So the intent of the regulation is to have physical counts and reconciliations. And as we considered whether or not a perpetual inventory would satisfy that, our conclusion is that it does not. So if the perpetual inventory includes a physical count, right, and the reconciliation is required, then someone can absolutely use that because it satisfies the requirements of the regulation. But we don't believe that a perpetual inventory that perhaps doesn't include physical counts or that does not include reconciliation in the same fashion as envisioned by this regulation, we don't feel that it's appropriate.
So this is a reconciliation every quarter, and these is only for C2 drugs.
Correct.
So if I have 10 C2 drugs and I do a perpetual inventory reconciliation for those drugs anytime during those 3 months, it doesn't mean they have to be done right on the same day, right?
Within 90 days.
You just have to do it within 90 days. So if you do one drug a day, you've essentially met that.
Okay, because I do think that most of the perpetual inventory programs, it'll tell you, okay, pull your morphine 2 milligram tablets. I can't remember if there's a 2 milligram tablet or not, but let's pretend, okay? that I know what I'm talking about. And so I actually count them and then I put it in there. I mean, I think that's how the perpetual inventory programs usually work. It's not all just, computer mojo. So that sounds like if that's the case, then in fact.
It may
that
be
would-
worthwhile, Debbie, for the board to ask the staff to provide some FAQs after this is issued that kind
Okay.
of explains how this will work so that everyone's clear as to what the requirement is.
Okay, because I think we've had testimony, and when I saw the couple letters, I thought, oh, yeah, I thought we had talked about that, and we were all very comfortable, but, so it probably is, it all worked.
Yeah, so I think that some of the comments talk about a physical count at the front end, but not the reconciliation piece at the back end where you're actually determining the losses. And I do think that this board has considered disciplinary cases where some of the drug losses have occurred because someone is in there adjusting the system. And so I think that perhaps allowing, if the board chose to allow for the perpetual inventory to serve as that without that actual reconciliation, I'm not sure that the full benefits of this regulation would be realized.
And from my perspective, I think that the definition of what a perpetual inventory is also the challenge. So my understanding of where the board's direction was was that to the extent that the acts that are being performed during the perpetual inventory satisfy the requirements of the regulation, then those are you don't have to make a separate effort to, if you're already doing the counting, I think is what President Gutierrez just described, if you're doing the counting as part of your perpetual inventory, that counting can also be used as part of satisfying the regulation requirements.
Well, that is the step in the reconciliation. You
Right,
count,
and
you
so
compare,
the challenge is not,
reconcile
but it's not because I have a perpetual inventory, I don't have to comply with the reg, which is, I think, it's that the tasks that you do as part of your perpetual inventory can also be used. There's no need to redo those tasks in order to satisfy the reg.
as long as
But I
the
think
count-
because of that confusion, it may be worthwhile to just do an FAQ after on implementation of the regulation as to what it means in a
Yeah,
perpetual
because I'm
inventory
looking
setting.
at the one letter, and from what you're saying, their definition of perpetual inventory meets what you're saying. It's counting and verifying the count.
It's the three
So,
steps, yeah.
Yeah, so it appears that
Okay.
the definition they're offering up is, you're
But-
saying would fit.
But the reg is still going to require that reconciliation piece, right?
And that's
There's
part of their
That has to be
definition,
done.
right?
Right.
And the whole goal of this is just to catch these drugs diversion a lot sooner. Before
Right.
it gets to the thousands and thousands of tablets that we see on cases. And this will allow at least some stopgap where someone's actually looking at these.
Yeah. And before the board actually votes, I would also want to sort of address two other pieces, just so that when we do our, the rulemaking pieces that follow. In terms of dispositions, there was comments about whether or not the term dispositions is confusing. Based on the, like a dictionary definition, disposition can include sort of the final arrangement or the transfer of care or possession to another. I see that as broad enough, but I do want to raise that so that the board members can tell me if for some reason that has a specific use in pharmacy that wouldn't mean sort of every option. For example, one of the comments had said, does it include the materials that have been taken from expiration of stock? It seems to me that any disposition would be included under the reg. And so as long as that's the intention of the board, I don't see that the use of that word is a problem.
I don't know if anyone here's undergone a recent DEA audit, but one of my sites just did, and it's grueling. I mean, they come in, they want to look at every single tablet, the disposition, and making sure that you've got accountability for that. So I think the DEA regulations are kind of in that direction anyway. So, any public comments? You were just waiting.
He's been waiting.
Good afternoon, everyone.
Good afternoon.
My name's Tim Lopez, and I'm a pharmacy manager at Community Regional Medical Center in Fresno. It's a 700-bed hospital. Thank you for hearing the comment I have here. So we believe that we have a couple of suggestions that might help clarify some of the wording of the proposed regulation, and you guys hit on one of them that I was going to talk about, and it had to do with the dispositions. So we're thinking that if we actually tease out what the disposition verbiage is, it would help kind of clarify and maintain compliance within the pharmacies. So instead of using the word disposition, we're suggesting that we actually tease out what that means. So for instance, we could say a review of all acquisitions, and instead of using the word disposition, we would then say dispenses, sales, expirations, shipments, and transfers. And the reason why we feel it's important to help clarify that is because if you look at the current Board of Pharmacy law book, dispositions used more than a few times. And each one of and there's multiple definitions of the word disposition in that law book. Sometimes it refers to a proposed performance or a disposition of a fine, or even within the use of using it for acquisition and disposition, it has a different meaning because they'll apply it to reverse distributors or wholesalers or radiopharmaceutical medications. So we just wanted to see if we could have an additional 15-day comment period, and my colleagues feel that we can actually put together a good proposal to use instead of the word disposition, but kind of teasing out what that means a little bit more.
Could that be accomplished just by guidance after the fact to basically have the board explain the disposition per the FAQs that we had recommended?
I think that would be great, yes.
So, and that's the reason that I asked the question I did is because I think as it's currently written, the term disposition refers to anything and everything that happens with
You don't want to exclude anything.
a dosage. There's nothing excluded. And with that broad definition, I don't think you need clarification. The only reason you would need clarification is if for some reason you wanted to limit it and say, no, we're not going to make you count those. But that's, my understanding is, we're going to count everything. And so from that perspective, I think the use of the word disposition is appropriate.
And
Well, one example.
Address those
And I think what I
things.
think I hear you saying is you want to fully understand what is expected so that it's clear when you have an inspector come, what are they going to look for? So if we get some guidance on that and that should help bridge that gap.
And just one example of what disposition, could potentially mean is that if the medication were dispensed in an outpatient setting, that medication is still intact until it's, potentially administration. So one could make the argument that if administration of the drug is part of that disposition, it kind of gets confusing. And I think that we could put a really good definition in place of that word disposition, and perhaps an FAQ is fine as well, too.
I will note that the rulemaking process, the board has a year, and the rulemaking was formally initiated July 28th of 2016. So you do have the ability to secure an extension, but it's for a limited period of time. And the regulation, once it is finalized, whether it's today or at a future meeting, does need to go through all of the control agencies for their review as well.
Thank you.
And I have another suggestion too on one of the paragraphs. So in paragraph, let's see, it's paragraph F. It talks about a reconciliation report that's done for an incoming or new pharmacist in charge and for an outgoing. And we were thinking, would it be possible if they were done at the same time of the new pharmacist in charge and the outgoing, could that one report that's done by both of them together actually suffice with the proposed regulation?
Yeah, under the requirements, the new pharmacist in charge has to do it. The outgoing PIC, it's whenever possible. So it's not a mandate for that one.
We heard comments that sometimes the outgoing PIC is gone. They're not going to be around to be able to do that. So to put that as a requirement in the regs would have been too difficult. I mean, ideally, I agree with you. That's actually the best way to do it, is to have them work together. But sometimes that's not possible.
But if we were to say that if they were to do that, then that would satisfy the condition.
Yeah.
Okay. And then, just so I understand the first part of it, so in that FAQ, when we talk about disposition, is administration going to be a part of that terminology?
So tell us about
disposition?
administration. So you're saying the drug's hanging on the shelf in an outpatient pharmacy, ready to be dispensed to a patient walking up to the window?
So I guess the way that one could look at it is that medication is still intact and it's still around until it's taken by the patient. So when you look at all the different steps in the acquisition and disposition, some people are taking it.
Outpatient medication?
That's one example for outpatient, or also for inpatient as well too. I guess we just want clarification that when it's in the part of the pharmacy inventory, it's the acquisition and disposition steps within that part of the medication, and not so much the documentation or the disposition end of it when the drug's being administered by the patient or to the patient, or in the case of an outpatient, it would be by the patient.
So it's been filmed as an order.
The regulation addresses the pharmacy, so it's the pharmacy's control. So unless the pharmacy is administering the drug, I
So
don't
that's
see that the administration, once the pharmacy lets it go out of their control, then I think it's not in your inventory any longer. I mean,
I think your concern is if it's on the shelf, right? Is that what we're talking about here?
So
you've filled that it's out of your inventory. It's not been picked up by the patient. Is that what you're talking about?
So it
I'm
would be,
unclear.
so in an outpatient, so in an inpatient setting, it would be that once when the medication is administered to the patient, that would be outside of the pharmacy's inventory, and that reconciliation report wouldn't have necessarily that documentation as part of that reconciliation.
Are you talking about automated dispensing cabinets, or give us an example? Going back to
So-
Debbie's morphine example.
Okay, so I guess if I just kind of walk through, in a hospital setting, how a medication would come. So if medication would come from the wholesaler to the inpatient pharmacy, and we have records of those medications coming in, the Schedule IIs. At that point, for most hospitals, that medication, when it comes from the wholesaler directly to the pharmacy immediately puts that in a big Pyxis machine in the pharmacy, usually called a C2 safe.
Right.
And we have documentation of those records. Then usually what happens to that medication is it goes from the C2 safe in the inpatient pharmacy to what we call an automated dispensing cabinet. Not what we saw at the presentation today, but like a Pyxis machine. And we consider that as part of the disposition. And once it goes to the automated dispensing cabinet, once there is a medication order by an authorized prescriber to use that medication, the pharmacist would review that medication order, and then that medication would be released by the Pyxis machine. And we have accurate documentation of those records, and that's where we wanted the scope to be within the acquisition and disposition portion of the reconciliation.
If you review H, that actually addresses it. So it says the pharmacist in charge of an inpatient hospital pharmacy or of a pharmacy servicing on-site or off-site automated drug delivery system, which includes the Pyxis, shall ensure that there's just all controlled substances are accounted for, access is only to health facility personnel, and an ongoing evaluation of discrepancies or unusual access associated with controlled substances is performed, and conformed losses of controlled substances are reported to the board. That's why we included that section.
And up through that point is great. I think that some folks are perhaps interpreting that it would go one step beyond that, where it would include the actual administration to the patient, that disposition portion of it. But if it, so from my
I don't think I'm worried about that.
Okay.
I think,
Yeah.
Have you
That's
been
not
burned
a
on something
concern
like
of
this
mine.
previously?
No, we haven't, but, people much smarter than me have reviewed this, and one of the concerns is that it would be interpreted that the administration of the medication, the documentation of that would be included in that reconciliation report, and that's why we wanted to make sure that if we used language that talks about all the disposition steps, excluding administration, would be helpful.
We've had extensive discussion on this. That was why item H was added for that purpose. Thank
Okay,
you.
Thank you very much.
Any other public comment? Okay, we've got a motion and a second. All in favor of the staff recommendation, all in favor of the motion, I should say, raise your hand. Okay, thank you. Now we're moving on back to the UCSD pilot program. Laura, have you had a chance?
I'm sorry, I think I found where it is, but I'm not. Could we maybe take a break?
Yeah, let's maybe take a 10-minute break, and then we'll come back, and then after we do that, we'll go into closed session.
Like today, maybe.
Sandwiches come?
We're going to get started. The only item we've got pending is back on item 13, which is the UCSD pilot. You guys want to come back up? I think we've got an update from our attorney on what it is we can do.
So based on what I was able to find out, I do believe that the board can take action if it wishes to continue the study as it is now. I do believe that the board could take action to extend that, and that means the full panoply of the scope of the study. The other thing that I think that the board could do, and I would caution that it be very conservatively done, is that if there is one particular aspect or two particular aspects of the study, the scope of the study that you're aware of, that you want to modify, that you could modify those. I am, however, hesitant to advise, and I recommend against modifying the sort of the foundation of the study without having the full the materials in front of you so that you know what it is you're authorizing.
So Laura, could we extend the current study for a period of, say, 6 months and ask the study pilot authors to come back to the enforcement committee to discuss a specified new study?
Yes. I think if you think there's, the goal here is that you want to draw from it that there's data that you're going to gather from those additional 6 months that's going to add to the board's ability to determine the effectiveness of the technology or the processes being
That'll focus maybe
tried.
like on patients. This has been an employee study.
If there's
or-
additional, I mean, even if the study itself, if you've got value to what you're having, but you want more data, then I think that's a justification as well.
So you should make a recommendation as to what additional things you can do that aren't going to break the bank, so that we can ask you to do that.
Or if they're willing to. I mean, that's going to be something that's up to them if they're willing to do
Our
that.
recommendation to you guys, or a request, was we are willing to continue the study of the kiosk. And then 3 variables were return to stock, time to pick up, and patient satisfaction at the kiosk. However, it would be an amendment to our IRB because we would not continue the regular counter.
But what I just heard our
But we would be
attorney
getting
say is that
additional
we could
information.
not do an amendment to the study.
Well, she said we could modify.
Yes, I think you can modify it in very limited. I'm very concerned that the portion that is being proposed to be deleted is a core
the study
of
too
the study element and taking out the counter. And the problem is that without all of the materials in front of me, I haven't been able to prepare that appropriately. But as I understand it,
the core of the study as it was originally designed is compare A and B and see what you get. And by taking out the A and only studying the B, I think that's a fundamental shift that would require a different
Could they
study.
reduce the amount of comparatives they're doing?
So I see it as if the study is, if you're, the type of amendment that I would envision that I think is consistent is, you spoke about, the board was talking about the type of prescription. Is it a new prescription or is it previously dispensed, thank you, prescription. So that's a very specific aspect of data that you didn't have previously that may be valuable to me, to the board in order to determine the value, because the whole point of this is that you're waiving a requirement in regulation in order to determine if this new technology or new process is appropriate and safe to the public. And so those are very discrete changes. My concern with the changing the foundational aspects of it are that you don't have the same level of review. So changing the what I would call maybe more of a like a periphery or an accessory like this, I think you understand enough about the scope of your study that you have that, and you're not really you're asking for a very minor change. And
So
my
we're
concern
keeping the
is
core
that-
elements of the
yeah,
study.
Yeah.
I have a question. So I just want to make sure I understand before we agree to anything. Because I understand that to continue to use the kiosk, we have to continue with the study, which is kind of the premise of where we are
Well,
right
so,
now.
right, for the board's perspective, though, it's determining whether or not to continue to waive a regulation, and it can only do that if it determines,
study.
if it's in the process of gathering information or data that's going to be valuable to it to make
Right.
a determination.
So today, we're at the point where we have done our study, and ultimately, the goal was to change and amend 1713. My question is, if we do the study for another 6 months, are you agreeing today to amend 1713 and continuing?
No, the board can't do that.
So in 6 months, are we going to be right back where we are today? I don't understand. I need to understand the process, because a year ago we came and presented, we wanted to do this study. We had our end goal. We're here today, and now we're moving forward with the study again.
I think you're right, and I think there's some basic questions that need to be asked. I think one of the things, at least that I heard from the enforcement committee, is that the volume of patients is not what we expected. It's a lot lower. It may have been the study design, it may have just been who's elected to use it, but for us to utilize a study of such small volume and so many OTCs, it's going to be difficult to change a whole regulation. I guess that's the bottom line I heard from enforcement. I don't know, those of you that are the enforcement committee, speak up, because that was why it was referred to the board to kind of review.
This is Sarah Lake from Asteris, and one point that I wanted to make, Amy, I know that was a concern. That was the IRB, that was approved, that was the sample
Exactly.
size, that was approved.
Exactly.
That's why we moved forward. Now, if that's not enough, we have dozens. We have your Baylors, your Vanderbilts, your Harvard, Mayo, Cleveland Clinic. Can I get you data from them? Can I get you data from some of these major facilities? We're doing a pilot with Baylor right now, with Texas, for this exact same thing. We're expanding their regulation for new prescriptions, including controlled substances, away from the pharmacy. Baylor is doing the exact same thing right now. Can we pull together some of those numbers? We have 1.5
should
million
work.
pickups.
And bring
1.5.
those to the enforcement committee.
Yeah, I think that should work.
But that's not
But-
going to
but-
resolve the issue at hand right now.
Okay with our attorney.
Sure, but I guess, let me just finish by saying, we have data we can bring. What we don't want to do is continue to come back. We've been here in front of the
Yeah.
enforcement committee or the board 12 times. It requires, we're a small company. It requires us to fly up to Sacramento most times. Hundreds of hours of doing this. We would just like to have some indication that there is an end in sight or that we're giving you the information that you need to make a decision.
And I think, I mean, and Laura, correct me if I'm wrong, but getting all that data from the other would be great to work on a proposed reg. But however, it doesn't address the issue at hand today, which is whether we can continue to waive regulations.
Yes, so there's two different issues that are going on. And one is whether or not to amend the regulation. That's not on the agenda. So, but it is being currently discussed in in committee, and so that can proceed. The other issue, and that's the issue that is on the agenda, is a study that UCSD is proposing, and it's under 1706.5 of the Title 16 of the California Codes of Regulations. And that says, in order to enable any accredited school of pharmacy recognized by the board to experiment with new and innovative methods for drug handling, teaching, research, or to develop new and better methods or concepts involving the ethical practice of pharmacy, the board enacts the following. And then it permits itself to waive certain provisions of its regulations. The only way it can waive provisions of the regulations is if it's doing an evaluation to determine whether or not there's new and better methods or concepts involving the ethical practice of pharmacy. And that's what I think the board members need to come from.
I think we understand that. I think we need to know what we need to do to continue in this study. If we just continue this, or do you want it tweaked, and then we're going to get to 6 months? We're going to be in the same place, it appears.
Who
It
does
just keeps
make
us
the
going.
decision on 1713? And
Well,
when
this
does-
board would make that decision, but the board is limited in what it can discuss at any given time based on its agenda and the materials. And
So it's not on the agenda
1713
today.
Is not on the agenda today.
And we can't, I mean, we can look at the Baylor studies and all of that, but that's in looking at a proposed future
Right.
reg.
And
It is
Right.
not in reference to the pilot that we're discussing today.
And the other piece of that, because you're asking about what the process is. So the process to amend a regulation takes time. So even if this were to make it to the next board meeting, the enforcement committee meets, or if it's going, I think it's enforcement that's considering it, right? If they meet and make a recommendation at the next board meeting, then the board initiates a rulemaking, and that rulemaking takes time to become effective. And you're looking probably at a year from the
So-
time the board approves it before an amendment to 1713.
But I think that's important to know that timeline,
Mm-hmm.
because if we extend it for 6 months, that sounds like we're going to be sitting in front of you again, and Kim's going to want to keep the machine going, and we can't
Right.
keep the machine going. We kind of need some realistic, she wants to keep the machine going.
And my question also is, what's different than when we went through this process in 2005? So we went through this process in 2005. California was the very first state to allow this piece of technology. We did the study with UCSD and Long's Drugs. We ran the study. During that time, 5 additional waivers were granted. We had Safeway, we had Walgreens, they were also running it. And then the 1713 was written, and that was a 2-year process, and we had 5 different retailers using the product, and we moved forward. I know things have changed. That was a decade ago. I'm not saying it's the same, but we came up with a solution then, so I'm confident that we could come up with some sort of solution today to allow us to all, work together. And I know this takes time. I'm not asking you, we weren't expecting to have an amendment to the regulation today, but we are hoping to have some direction so you don't have to see us another 12 times.
No, you do have your options. I mean, I understand that you do spend the time, do the pilot program. Actually, if you would come in with the very overwhelming data that from your pilot study, that would convince the enforcement committee members to think about whether they should change that's the section. But even if we remove that section, it still would take a while to go through the statute changes.
No,
Provided that you have convincing evidence. But by doing this, at least you're taking a first step forward to make believe that to them that could happen. So if you think you could drop the project too, but maybe 6 months from now, you come back with overwhelming evidence from all across the country, try to convince them that the project would work, that would be another strategy to do. Or you could continue to this project and bring more strong evidence in addition to all the other stuff to ask the enforcement committee to change the mind. That's the next step to do.
Well, so I now have a question. So the enforcement committee is saying the evidence is not enough. Therefore, we need to bring more evidence, correct?
I don't think that's
So
correct.
I think that the
Well, that's what
enforcement
it is.
committee
That's not
is
correct.
discussing the issue, and they're, as part of that, they're assessing the different environments. They're looking at what data is available. They were hoping, using your study as well. They're initiating a policy discussion, and part of that is looking at the data. Part of it is also looking at what they think the data supports and how that is going to impact consumers, both the pros and the cons. So they're discussing it.
And that will continue on regardless of this.
Right.
So
But what I'm hearing-
one isn't dependent on the other.
Yes, so those discussions are going on. We can
So,
contribute.
yeah,
by
they can get
bringing
moving
more
on the
information.
regulation part without having this additional work on your study, but
Right.
you can't keep it alive
That
without
keeps it running.
Yeah.
So the one thing if you did extend your study, we would get more numbers and we would get more data in terms of volume that could be assessed.
But
But
what
but all
I'm
the other
worried
data they
about-
have will be helpful.
Yes, it'll be helpful, but what I'm worried about, I am hearing that we can bring other state data, which may be the overwhelming piece.
regulation
But that's, remember, there's
Okay.
two different things. There's two different things. If we're going to talk about the regulation discussion and the policy discussion, yes, all of that can be in.
Yes.
But that doesn't impact the pilot that we have going on now.
I
That's the
understand
second
that.
issue.
I do understand that, but then I'm trying to say, the reason for me to continue doing this study with Kim and this is, one, we keep the kiosks going, which we want to do for patient care, because we don't want to stop that. All right, but be clear, I'm hearing we need to have the study be the same. This study is not going to bring overwhelming information to you, because I think
I don't think
we
that's
are not-
necessary.
Yeah, we are not collecting the things you want to know. It
No.
also appears.
As long as we have all the information from
We-
everywhere, I think we can continue on the path with the regulation.
And this study is only going to keep giving you bits. It's not going to be another
No, no, no,
500
I-
people.
I wouldn't worry about that.
So the original study wasn't to assess demand anyway, right?
No.
Isn't that what you guys
No.
said? Okay.
Right.
So I just want to be clear on what continuing the study is going to bring you as far as the regulation. I understand, and we do want to continue to do it to keep the machine running.
So is it okay, I mean, Laura, can we approve a waiver extension just to be able to keep the machine running?
Sorry. I believe that the board's ability to grant the waiver is tied to the value of the study. So if you believe it has value to continue to collect the data, then I think the board can agree to extend the study.
That's why I asked that question. I just want to make sure on the record we've got appropriate
Well,
direction.
It's got value to all those who are using the machine.
Well, it's,
but the
waiver is
provision-
not.
The waiver, it's only to develop new and innovative methods for drug handling, teaching, research, or to develop new and better methods or concepts involving the ethical practice of pharmacy. So that has to be, that's the core of what
so the
you're doing.
additional data that we're going to get will be an increased number.
We'll add to it, right?
Yes.
No, thanks.
So we then need to make a motion.
Okay.
Sure.
Is that what you want to do? That's true. But before we make the motion, we better make sure.
So you can make the motion to authorize it if they want to, I mean, they don't, that
So we
doesn't
can
mean
make a
that
motion and they don't have to do it.
They don't have to do it. So you
Correct.
they don't need to decide
So I'll make the
today.
motion that we extend the waiver for another year.
Yeah,
To-
second,
in
yeah.
order to,
Ricardo
In
said.
order to gather additional information and statistics around the kiosks. But is a year enough, or do we need longer than a year?
It depends on how long it takes to do the reg, so
So-
It may need to be longer than a year.
The requirement is that it be sufficiently definite, and it would not be the first time that you've done an extension. So personally, I would not go beyond, I would recommend that a year is
And then revisit it after a year.
window, and then you can reevaluate.
Do you want
it
to
if
add
need
in
be.
the fact that you want the new prescriptions,
Only if it's a benefit to the board.
to actually look at new prescriptions?
Can we do that?
But can we do that?
I believe you
Yes,
can.
'cause it's not a
My
core
concern,
part.
that's not the foundational principle of the, as I understand it, of the study.
So how would you word that, Anne? And to expand the scope?
The review of the data.
Expand the review of the data?
I think it's segmenting the new to be truly new, not previously dispensed.
Debbie, it's kind of like when we had before we asked them to segregate out the therapeutic classes of the drugs.
Right.
That were, so this is kind of a similar request, and it would add more ability to get.
You get more value
Okay.
out of the data that you're receiving, so you would
But
be
there is an
requesting-
understanding that you're going to have to continue to compare it with the
Yeah.
pharmacy counter.
So, okay, so can we, and we may not have heard everything you said because we were talking. Okay. The most labor-intensive piece of this is the counseling, those logs that the pharmacist has to keep and they fill out. The way we did it in the comparison is already in there. For the regular counter, we did a sampling of that. Would it be a major change, or would it be acceptable if we did a sampling also at the kiosk?
Counseling?
I think that's our biggest concern.
No, the log.
Just
We will
maintaining.
counsel.
Yeah, the log.
It is the
It's a data
log.
collection log that they fill out every time.
Well, don't you think that's part of what they do behind the
we need to-
magic screen, and we don't have to
So
rule on that?
The board, so what I would recommend is, I think that the board can make the motion, then we can look at the actual scope of what was prepared to determine whether or not that modification is consistent with it. Because I think that's, we're getting into the pieces that I'm uncomfortable with, because I don't know if those are at the core of the study. I do know that you don't have data, so if certain data about the prescription, maybe other things, so that is a small.
Could we delegate to our executive officer to review those details with UCSD?
I don't think you need to,
We don't need to
I
do
mean,
that.
certainly that's the case, but I don't think it needs a specific delegation, because I think that
We'll still do it.
certainly the executive officer, maybe in consultation with the president,
Okay.
can evaluate that to see whether or not it's consistent with the study that the board previously authorized.
Okay.
So Debbie, your motion?
So do we need to, but we don't need to include all that in my motion?
No, no. I
That's kind of
I think
understood.
a motion.
Right.
And so I am including in my motion that we're going to request that Sharp includes the information about the new prescriptions.
And I'm sorry, that's the part we probably didn't hear because we were talking. What exactly is
Do
that?
we need to have that?
It was
in
what
our
Ann was
motion?
requesting before,
I think if the
whether
board
which
wants
Which
that
one were
data,
they-
yes.
actually
Truly
knew.
Greg, I think it gives validity
Yeah, you're right.
to the study, and I think it's a very important aspect.
Okay.
So we'll give you that, and we'll take away the consultation log.
Well, I mean,
All right,
seriously.
okay. If that works, it's fine.
So.
Right, so you propose back
I don't
to
think we
the,
can say that.
to the
in-
executive officer
This
and
is
the.
not a
No, I
we
said,
can't negotiate.
if it works to give us what we need, it's fine.
Yeah, but I think
I-
that should be a committee decision.
Yeah.
Right.
Rather than any of us individually.
Yeah.
Right. So I'll say
Well,
should be
the-
instead of is.
So
Well-
Debbie, do you want to repeat your motion?
Well, I was kind of doing it off the top of my head, but let's see. That the board would grant a one-year extension to Sharp around their
To
kiosk.
UCSD.
Around their,
UCSD.
what's that?
To UCSD.
Oh, UCSD, sorry. To UCSD, around their kiosk, and to include the additional information around new prescription.
The stratification of the data to reflect the new prescription.
With this, okay, additional stratification of the data to include the new prescription.
Okay, is
May
there
I
a
wordsmith?
Can you wordsmith
So
this?
do I hear that the board would like to extend the pilot study for another 12 months and also additionally request that data that it receives back includes a distinction between new prescriptions and previously dispensed prescriptions?
Yes.
That's what it
Well
sounded
said.
like.
Second to that motion.
I'll second it.
Stan, second. Board
I would
member
like to remind
comment?
everybody, Debbie's going to be here for another 4 years.
Public comment. All in favor? Okay.
Good job, Debbie.
Yeah, well,
All
now
right.
let's go to the committees.
So that is the conclusion of the open session, and now we're going to go into closed session. Laura, are there any cases that I need to mention in open session about closed session?
No.
No. Okay. Have a good rest of the day.
Just so we will go back into open session very briefly, just.